My lord, I beg to mention, my lord, this is an unlisted matter, my lord. This may be taken up today at 2, my lord, because we are challenging the order of the CAT, my lord, wherein the direction is there in violation of order of this honorable court to regularize some part-time casual workers, my lord. This is having, my lord, all India repercussion, my lord. All the casual workers are knocking the doors of BSNL. So matter may be taken up at 2, my lord. I think.
Today it is listed or what?
The unlisted matter.
Unlisted.
At 2, my lord.
Tomorrow. Not
Tomorrow I am not here, my lord. So
that's but it's not possible. Sir.
let it be on Thursday then.
List is already heavy.
Yes,
Not possible.
let it be on Thursday then.
Thursday, okay.
Thursday,
no problem.
Lordship, I beg to mention item number 22.
22. Yeah.
Yes. We are led by Mr. R.B. Fukon, who could not attend court today. I pray that the matter may be adjourned for today.
Is anybody from other side?
We have taken consent.
You have taken consent.
Yes, Your Lordship.
Okay. At the request of London, so is this matter on?
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 35, lordship.
35.
35, lordship. Kindly matter may be adjourned for 2 weeks, lordship.
I'm not for that.
You know,
I taking consent.
you're already taken consent. Okay. Arjan,
May please, Lordship.
Of like-
My Lord, I beg to mention item 41.
41.
I have
Yeah.
taken the consent of the petitioner and for the respondent. My Lord, in this case, a particular rule is under challenge.
Okay.
Now, there is a connected matter, my Lord, WPC 2151/23. The same rule, my Lord, is under challenge. So both the matters, my Lord, may be taken up together after 2 weeks, my Lord.
Okay, at the request of London, so and so, list this matter along with the petition number so and so.
2151/23.
You-
Obliged, my Lord.
Please inform.
May I please?
one.
My lord, I beg to mention item number 33, my lord.
33.
Yes, my lord, with due consent of the other side, my lord. My lord, matter may pass out for 2 weeks, my lord.
My lord, I'm for the respondent number 5, my lord. I'm going for a fixed date after 2 weeks. Oh, no,
Item number 33, my lord.
sorry, my lord.
33. Okay, then. Arjan,
One more pair, my lord. Item number 60, my lord. I have taken consent from.
My
the
lord.
other side.
60.
60, my lord.
60, my lord.
Hearing, my lord.
After 2 weeks, any date may be fixed, my lord.
You just inform the court master.
My lord, my lord.
There is an interim order that will be continued.
60 में कर देना at the request of London so and so. This is matter is urgent. Interim order if I need to continue till next date.
Wait, please.
Date is now whatever the date.
Hello.
Wait, please, Mr. Lordship. Lordship, with the consent of the other side, I beg to mention item 25, 26, and 27.
26, 20,
25, 26,
25,
26.
26 and 27.
Yes, Lordship. Lordship, matter may be kindly adjourned and a date may be preferably given.
Any date of your choice, okay.
21st.
Urgent at the request of so and so, urgent, list on so and so. Yes,
Highly obliged, Lordship.
May I please, Lordship, with consent of other side, Lordship, I beg to mention item number 29, Lordship.
29, yeah.
Yes, Lordship. Kindly this matter may be urgent for the day, Lordship. And
Who is for the other side? You are for the other side?
No, Lordship.
I have taken consent, Lordship.
Okay, urgent.
May it please your Lordship, I beg to mention item number 40, Lordship.
40.
40, Lordship. As per my client instruction, we want to withdraw this case, Lordship. We want to withdraw this case, Lordship.
You want to withdraw this? case.
Lord.
You are for the
Appellant. I'm
Okay.
for appellant, Lordship.
Okay. Then concept of the appellant on instructions has submitted that she wants to withdraw. The writ appeal dismissed as withdrawn.
Okay.
My please, your Lordship. Lordship, I beg to mention item number 42.
42, yeah.
Lordship, memo for the absence of my seniors have been already submitted. May the matter be adjourned for today.
Urgent.
May I please, Lordship. Lordship, I am for respondent number 6 and item number 42, Lordship.
Fine.
The Lordship, term of the petitioners has already been expired in the month of
You are
December
objecting to
2023.
adjournment or what? You are objecting to adjournment.
No, Lordship.
Actually,
The term of
Lordship, inform the.
the term of the petitioner has already been expired, Lordship, in
The
the month
matter has
of
become
December.
infectious.
Yes, Lordship.
Let
And
the,
the
on the
petitioner
other
has
day,
taken-
the, we'll fix a
After-
day,
Lordship,
make a
after
mention on
20
that day.
After 20 of this month,
Any date after 20 of this month.
20
May it please your lordship.
Obliged.
Because I'd like to mention item numbers 47 to 50 of today's list, Mr.
47 to 50.
Yes, Mr. I am appearing for the appellants, Mr. I am led by Senior Counsel Mr. I. Chaudhary. He is not available today. So may I pray for some other day?
Have you informed the others?
Yes, I have taken the consent, Mr.
Arjun?
Obliged.
May please your lordship, paying for listing of a matter, your lordship, it's a tender matter. And we are not having any interim order, lordship, and the department is proposing to sign the agreement with the private respondent, lordship. There is some urgency, lordship. Can I pray for 16th of this month, your lordship? It is not inconvenient, lordship. Much obliged, lordship. 16th Friday, it will be Friday, lordship.
May I
Much
please your
obliged.
lordship, with regard to item number 62 of today's list, my lord. 62.
Yeah.
We have filed a written submission before the court today, my lord. The records may be called for.
Who is for the other side?
We have filed a written submission, my lord. The records may be called for, my
The record is to be called.
lord,
From
on
whom?
the filing section, my lord.
You want to argue today itself?
Yes, my lord.
Get the record.
Obliged.
Daily list for this item 1.
My lord, as per official, my lord, service is completed, my lord. The matter may be fixed for final disposal on 6th of March, my lord.
You are for the,
I'm the appellant, my lord.
Presumption लेना है कोर्ट का ये सब बहुत तो ये this is the Lodhima court, registered judicial. तो presumption लेना है कि नहीं, सर्विस हुआ कि नहीं, उतना ही और नया स्टेप लेना है कि नहीं बच तो Lodhima कोर्ट का जो ये ऑर्डर court accept it in just assisting.
yes,
My lord, fix a date for final disposal, my lord, on 6th, my lord. Service is completed.
okay, as per the office report. The service upon the respondent number 1 is really affected. Let this matter for. It is already admitted
Yes.
Already admitted, my lord.
for final hearing in the month of March
My lord. 6th of
2020.
6th of March, my lord.
6th of March 2020.
March, please.
Item 2 and 3.
Delay of 557 days, counter affidavit not received.
May this lordship, kindly pass out for time being, I'm appearing on behalf of R. Majumdar, Education Department.
My lord, may I pray on 16, my lord, today,
16th,
16.
but there is counter affidavit to the.
My lord, so far the delay is concerned, they have filed an application for continuation of the delay. We have again filed an objection to the delay, then they filed a rejoinder, so giving the explanation. But even from the explanation, I don't find that they have any explanation after 2018. Others is all inter correspondence between the lawyers and the department. And the last correspondence was of 2018. Your lordship will find at page number 52. So after 2018, I think this review was filed in 2023. Those delays are also not explained. So, but today I'm leaving for Delhi, my lord. I have a matter tomorrow there. So I pray, my lord, that matter may kindly be taken up on 16, subject to your lots of convenience. Or any other day.
Already many matters.
Any other day, subject to your lots.
This one 21st.
Yes. Yes. We are obliged.
Yes.
Item 4 to 7.
May I proceed?
Your lordship, may kindly produce the order dated, your lordship. 16/11/2023, your lordship.
Fine.
16/11/2000 in WPC 5042/2014.
Fine. But this GMD has already, you have not submitted the report?
Report is not report, Lordship. In fact, a committee has been constituted. That committee was not there earlier. It has been constituted, and I'm submitting a list of that notification of that constitution law.
Also, your town vending committee,
Yes, Lordship.
status of the process of demarcation of vending zones.
Yes, that process is going on. Once this
Going
committee
on.
is presently going on, Lord.
And
Lordship,
you
today what I'm
you have
submitting,
already constituted town vending committee.
yes, it has been constituted.
Where is that? You have not placed it on record.
Lordship, yes, I have not filed any affidavit, but the notification is with me, Lord.
File it on record.
Lordship.
Because on last occasion, the court has asked you to produce the notification on record.
Lordship.
Likhe, Mr. Swanto has submitted that the town vending committee has already been constituted and notification in respect of has also been issued. He prays a week's time to produce the same on record. List after a week ki date hai na, koi list on so and so. Yes,
Lordship. Lordship, may I pray for segregating item number from others, Lordship?
why?
Lordship, this matter relates to, construction of a separate land for the elderly persons, Lordship, on the footpaths.
Construction of
Separate land,
separate land.
yes, for the elderly persons, Lordship. So petitioner also,
I am not appearing in that, Lordship.
This construction of land means, how do you construct land?
that is the prayer, Lord.
Construct of land for elderly people for what?
Separate land on the footpaths, Lord. Separate
lane.
yes, Lord.
Lane,
Yes,
separate lane.
yes, Lord.
So it's almost connected matter here. Sir.
Otherwise, Lordship, in that matter, Lordship, we have filed our affidavit, and there we have stated that management of the roads are basically done by the PWD department, Lordship. But if
But Mr. Nayak, there are many places in the city, Guwahati city, where footpaths are blocked. Vendors are selling vegetables, etc.
Almost
This
all.
is glaring. This is something everybody sees. What is so legality? What are the legalities about it? You have to clear the footpaths. That
yes,
is the
Lordship,
job of the
either
GMC.
either we have to clear the footpaths, Lordship, or we have to regularize them, Lordship, by
Not to
declaring.
regularize them, you earmark some other place for
Vending
these
zones,
vendors. This is not the direction earlier this court has passed.
Lordship. So far as the present petitioner's cases are concerned, Lordship, remaining cases, in those cases, they have already been evicted, Lord.
In some, not all, your lordship. There is an act, your lordship, by the provision of the state act, your lordship, they are to create vending zones, your lordship.
What action has been taken pursuant to the order? But by the footpath has been cleared on the Yes.
Okay, that we'll list it after 1 week. And since the town vending committee are already constituted, now please give us a plan of this clearing the footpaths and to earmark some other place for vending zones. Where is that?
Lordship, if your Lordship make some observations, Lordship, it will
What?
be.
The observations are already there, sir.
Lord.
Last occasion, the court has already made specific this. You have a look at this order sheet of dated the 3rd of March 2023. In the meantime, the authorities of the Guwahati Police Municipality shall in consultation with the police propose a plan for systematic placing of vendors in thickly populated areas. The direction are already there.
Lordship,
We go through these directions
Right.
and submit a concrete proposal by the next date of it.
Lordship, I kindly make it 2 weeks.
Okay, 2 weeks.
Right.
क्या लिखा है एक मिनट ऑफिस में time prayed for is granted. Mr. So and so is also directed to place on record the proposed plan for systematic placing of vendors in thickly populated area by the next date of hearing.
Lordship.
Just after 2 weeks. Ka date de.
Item 8 to 11.
Affidavit was supposed to be filed by the.
On behalf of respondent 4, 5 and 6. Yes,
The states also have not filed any affidavit.
state has also not filed any affidavit.
We have not received.
Ultimately, state affidavit will be required, Your Lordship.
So affidavit of this respondent number 4, 5 and 6 is more important.
Lots more important.
Because as per this complaint of the petitioners, this Assam Backward Commission has deleted that. You are appearing for Mr.
My lord, I appear for respondent number 1 and 5, my lord.
One and
My lord,
five.
we are following the, my lord, direction given in this particular impugn order at page 30.
By whom?
It is by the, my lord, Department of Social Justice and Employment.
Who is appearing for the Department of Social Justice and
There is a
Empowerment?
standing document. But there is a standing document.
Name is not reflected.
It is reflected in item number 11.
11.
Yes.
Item number
Yes,
11.
10 and 11 reflected, my lord.
Then where is he?
There is respondent number 3. No, item 10 over.
Assam Social, SC Social Justice and Empowerment,
Yes, sir.
GA.
Mr. Das, RM Das is the standing counsel,
Yes,
is it?
sir. And my lord, for this session, my lord, by from May onwards, my lord, the NEET exams will start probably. So,
So nobody has filed reply till date?
No,
there is a main
no
department
one
under
has-
this.
Single respondent.
not a single one.
Lord, we will run, my lord, the respondents, my lord, under 3 weeks time, my lord. In the meantime, we will try. Whatever it's.
Who is, if anybody is here appearing on behalf of the council, then only we can give time, otherwise what is the point?
Lord.
Pass over.
Can you please find out if Mr. RM Das is available?
Item 12.
Service upon respondent number 4, 5 and 6 is not complete.
Lordship, the respondent number 6 in fact has filed, Lordship. We have filed, we have served dusty copy also.
4, 5 and 6. Who is appearing for the respondent number
6 has filed Wakalam, respondent number 6.
Who is appearing for the respondent number 6?
I have seen Mr. S. Bothakur has appeared.
But what about 4 and 5?
Lordship, the matter may be placed before the Lojima court so that we can track the postal.
We lodge him up. Please the matter before.
Lojima আহিব দিছে postal
Take it.
Okay.
6, I am
for the-
appearing, Your Lordship.
Yeah.
I am appearing for respondent number 6. My name has not been shown, Your Lordship.
Okay.
Right now,
As per the office report, service of notices upon respondent number 4, 5, and 6 is not complete. However, Mr. Stonethrow put in evidence on behalf of the respondent number 5. In respect of respondent number 4 and 5, the office, the registry may check and thereafter place the matter before this court.
He is appeared for number 6.
4 and 5, sorry.
briefly obliged.
Afterward, now, report for the timing and for the timing.
पासवर्ड पर टाइम नहीं है पहले वाला मैटर जो है पासवर्ड पर
Hello.
पासवर्ड मैटर यस
8 to 11.
Sorry, Your Lordship. Lordship, actually, we have not received any instruction, Your Lordship. Lordship, kindly allow us some time, Your Lordship.
you are appearing for on behalf of
Social justice, Your Lordship. Respondent number,
social justice
respondent number 3, Your Lordship.
respondent number 3
Yes, sir.
you are supposed to file reply or the others are also supposed to file reply
Others are also supposed to file reply, Your Lordship.
but on whose behalf the name the name of that particular community is deleted
Record plus commission.
we need an answer from that department why the
Yes,
names
that has to be answered by respondent number 4, Your Lordship. Assam Backward Classes Commission.
Ms. Deka, you are for the National Commission.
No, Your Lordship.
Then why are you saying respond number 3?
Lordship, she is referring to item number 11.
I am referring to
In
item
my
11, Your Lordship.
item number 8, it is
you are appearing for whom
Lordship, I am appearing for respondent number 3 in item number
what's the
11.
name of the respondent
Lordship, Principal Secretary to the Government of the Department of Social Justice and Empowerment.
naturally you are supposed to answer the why their name was deleted from the list of
Lordship,
backward
Lordship.
classes.
Yes, Your Lordship, I will take instruction, Your Lordship. Kindly allow me some time, Your Lordship. I will take instruction.
Stonethrow is appearing on behalf of the Social Welfare Department,
No, yes, Social Justice, Your Lordship.
Social Justice Department, there's some time to file counter to the writ petition, time plate for is granted, list on so and so.
I am obliged.
How much time?
Lordship, 2 weeks time, Your Lordship.
2 weeks time, list on so and so did enough.
Obliged, Your Lordship.
Item 13 to 17.
May I please, Your Lordships? Today I need some accommodation, my lord. Leading counsel is under bereavement, so may me kindly.
Yes. He's seeking some time.
Lordship, in item number 15, I am appearing for respondent number 5, Lordship, newly impleted.
Item number
15, 1 5.
15.
We want to file
Anyway,
a,
he's seeking time, you may do whatever.
Yes,
you want
Lordship,
to.
I have no objection.
At the request of land council, so and so, does this matter when?
After 1 week, my lord, any day.
10 days के बाद की date है.
Much. God bless.
Item 18.
Lordship, matter really, the contempt proceeding, Lordship, respondent violate the honorable court's order, Lordship, and they have filed a affidavit, Lordship, that was filed for the month of November, Lordship, stating that no, ultimately they did something else, Lordship, in the order dated passed by the honorable division bench that they should dispose of, respondent should dispose of the representation. Till date, no order has been passed against the
Is
representation.
the order the division bench?
Lordship, page 17 of the contempt petition.
Page 17.
Operative portion of the order. Page 17, Lordship, para A.
What is your reply to it?
Yes, Your Lordship, we have filed our affidavit and against his reply also yesterday I have received one instruction with there it is stated that with concerned officials, Your Lordship, that verification was done and accordingly the deputy commissioner has passed on speaking order. And in that speaking order, it is mentioned that these are government khas lands, so they are not entitled to get, Your Lordship. This is the- We have filed our affidavit.
Yes, so they have already decided your representation.
Lordship, but order was not communicated with the petitioner's lordship. Lordship, we have also filed our reply, Lordship. In the reply, I have annexed a letter that was, Lordship, issued by the authority. Lordship, kindly have a look at page 39 of the letter issued by the authority, Government of Assam, Lordship, on 20. Lordship, page 30 and 39 of the affidavit in reply.
Thirty-eight and 39, yeah.
Lordship.
Yes.
That was the order communicated by the office of the deputy commissioner, Lordship. Kindly have a look at para 6, page 39.
As per the records, old
Lordship.
LAFC case, 50% payment was paid to the interested pattadars, including petitioner in position earlier. Yes.
Lordship, that only they admitted that 50% of the payment was made. Rest of the 50% was still date not made.
Mr.
But
Consul,
land was made Sarkari by
Mr. Consul,
Lordship.
the division bench has disposed of the appeal by giving a direction to move an representation, and they are required to decide the said representation within a stipulated time. The division bench has not given any direction that decide the representation in this way or that way.
Yeah.
Once they have decided the representation, then prima facie we are of the opinion that the order passed by this court has substantially been complied with. However, even if you are aggrieved by this order, you can avail separate remedy available to you under the. Okay. This contempt petition is filed by me. petitioner alleged non-compliance of the order passed by this court on 13/9/2022 in writ appeal number
60.
the writ appeal number 60/2022. Full stop. While order dated 13/9/2022, the division bench of this court has directed the respondents to decide the representation filed by the appellants, to be filed by the appellants regarding payment of compensation, 50% of the remaining compensation within a period of 3 months from the date of receipt of the order dated 13/9/2022 along with the representation. Full stop. Learned counsel appearing for the respondent has informed, has produced the order dated, produced a communication, the produced copy of the communication dated 11th of February 2024 issued by the Assistant District Commissioner Kochar, Silchar, wherein it is mentioned that the representation filed by the appellant has already been finally decided. Full stop. The communication dated 11th of, copy of the communication dated 11th of February 2024 is taken on record in view of the fact that the representation filed by the petitioner has already been decided. We are of the view that substantial compliance of the order passed by this court has already been made. Hence, no further order is required to be passed in this contempt petition. Same is therefore disposed of, notice is discharged. However, it is open for the, however, if the petitioner is aggrieved by the or by the decision of the authorities concerned of deciding his representation is their representation, petitioners their representation, they are free to avail appropriate remedy available to them under the law.
Item 19.
Sole respondent.
Sole respondent. Sole respondent.
May I please your lordship? Lordship, as per official dated 25/1/2024, service report regarding sole respondent is awaited, your lordship.
The services on the sole respondent is not complete.
Lordship,
As per the office report, the service is not complete till date.
lordship, this report is awaited, your lordship. We take steps.
Fresh notice.
Yes, your lordship.
As per the office report, service of notice upon the sole respondent is not complete. Let fresh notice be issued to the sole respondent returnable on so and so.
High level.
Item 20.
Well, please, your lordship. Lordship, the IA has been filed for condonation of a delay of 49 days, my lord.
Fine.
What has happened is that, my lord, on the court, on the earlier date, had asked us to take steps by way of dusty. We have taken steps. The opposite party, respondent number 1 was not there, so it was served upon his elder brother. However, the court had again asked us again to take steps, fresh steps by way of dusty.
Now he has refused to accept the notice.
He has refused, my lord. I have filed another affidavit, my lord. It is page 17, my lord.
You are appearing for whom?
I'm appearing on
Sorry, number 7, lordship.
Respondent number 7. Who is the respondent number 1? Rupali Nara.
Rupali Nora, my lord. She has refused to accept notice. my lord. Well, page 24 is a bus ticket. The advocate's clerk had traveled to Majuli to serve notice by way of dusty. She has refused to accept notice, so we have informed the same to the outpost, Colony outpost, Majuli, in presence of 2 witnesses, Narayan Nath and Deviram Tahu.
The additional evidence filed by the
What about the other respondents?
Department of School Education.
Respondent numbers?
That will be respondent number. 2 to 6 months.
My lord, respondent number 8 has expired.
Respondent number
8. During the pendency of the writ petition, my lord, she has expired.
Bhagiram Das.
Sagiram Das.
Respondent number. Respondent number.
Any respondent 4.
Wait for you.
It is also reflected in the order that he had expired, page 26 of the writ appeal.
So the no requirement of bringing his LRs on record.
No, my lord.
What's the matter about?
My lord, the matter relates to my lord provincialization of services under the 2017 Act. What has happened is that my lord, my services along with the service of respondent number 7 was provincialized. The opposite party number 1, respondent number 1, he has filed a writ petition challenging the appointment of the respondent number 7. What has happened that after the filing of the writ petition, my lord, the learned single judge was pleased to set aside my appointment. I was a respondent number 6 in the writ petition.
Along with the other respondent,
No, my lord, only mine.
only your.
And in fact, my appointment was not even challenged by the writ petitioner.
You're appealing for?
I'll appear for 2, 3, 5 and 6. That is the state respondents.
5 and
education.
6.
Yes, my lord.
So you're the state. And you are appealing for respondent number 4. District level scrutiny committee.
My lord.
What about the respondent number 7?
He
You are appealing for the respondent number 7. Respondent number 6 has already is expired.
8.
Respondent number 8 and respondent number 1 has refused to accept the notice. Okay, what do you want to say about the delay?
He had provincialized his services, my lord. Now,
Delay in filing the appeal.
49 days delay, my lord, can be controlled.
You are also agreeing of as per the office report. The notice upon the respondent number 1, notice of application under section 5, the limitation act upon that is already served upon the respondent number 1. However, none is appearing on behalf of the service of notice upon the respondent number 1 is complete. Stop. The matter comes upon for consideration of the application under section 5, the limitation act, with a prayer to condone the delay of 49 days in filing the present appeal. Stop. Learned counsel appearing for the respondent number 2 to 7 has not seriously opposed the application. Having heard the learned counsel for the parties and after going through the contents of the application under section 5, the limitation act, we deem it appropriate to condone the delay of 49 days in filing the present appeal. Hence, the application under section 5, the limitation act is allowed. The delay of 49 days in filing the present appeal is condoned. Miss this matter for admission after 3 weeks. The registry is directed to register the appeal and thereafter listed for admission after 3 weeks. In the meantime, parties may complete their pleadings.
My lord.
Item 21.
Delay of 73 days service is not complete.
Yes.
Await return of notices of the answered respondents for 3 more weeks.
Item 23.
Lord, there's a delay of 30 days in preferring the appeal.
Yes.
One of the primary ground taken is that the order he was not aware of. My lord, only when a consequential order was passed, the petitioner came to know about the passing of the order by the High Court. And in the process, my lord, this 30 days delay has occurred. There's a private respondent also, my lord.
Notice has not been issued.
No, my lord.
You are appearing for
Lordship, I am the state government for deputy commissioner Lordship.
private respondent or state?
There's a private respondent, respondent number
Private
6.
respondent also. You are appearing for the state.
My lord.
The
State,
respondent number
two only, my lord.
only 2.
My lord.
Let the matter comes upon for consideration of the application under section 5, the limitation act with the clear to control the delay of 50 days, 30 days in filing the present appeal. Let the Ms. So-and-so is appearing, Ms. So-and-so is appearing on behalf of the respondent number 2. Let notices be issued to the, let notices of the application under section 5, the limitation act be issued to the respondent number 1, 3, 4, 5, and 6, returnable on so and so.
Lordship.
You may file your reply by the meantime.
RM Das is also.
I'm appealing for respondent number 1,
1, 3, 4, and 5. Okay. So continue, Mr. Anand Das is appearing on behalf of the respondent number 1, 3, 4, and 5. Ms. So-and-so is appearing on behalf of the respondent number 2. Let notice be issued to the respondent number 6, returnable on so and so.
Lordship. Obliged.
7-3 all of your तारीखों पर लगी बस steps level में
थोड़ा सा check कर लेना, ज्यादा नहीं है cases. Listen.
Item 24.
This I has been filed, my lord, for continuation of deal of 32 days, my lord.
32 days. Yes.
Lordship, in my petition, the IA, the number of days is not mentioned. How many days delay?
I got the service question with the
In para number 2, they have handwritten 32 days.
It is blank in my application.
Actually, they are
Lordship, delay continuity up to my lordship.
they are appearing to the response.
All the respondents. You are appearing for all the respondents.
Lordship, state, 2 and 3, my lord.
Okay?
2 and 3,
2 and 3.
my lord.
Yes,
You are appearing. Okay. The matter comes upon for consideration of the application under section 5, the limitation act with the prayer to condone the delay of 32 days in filing the present appeal. Having heard the learned counsel for the petitioner as well as the respondents, and after going through the contents of the application under section 5, the limitation act, we deem it appropriate to condone the delay in filing, the delay of 32 days in filing the present appeal. Hence, the application under section 5 of the limitation act is allowed. Delay of 32 days in filing the present appeal is condoned. Registry is directed to register this appeal and place it before this court for admission after 4 weeks. In the meantime, parties may file their complete their pleadings.
Deeply obliged.
obliged.
Item 28.
May it please your lordships. Lordships, may be pleased to turn to my lord. Page 93, my lord.
93.
93, my lord. This is in, my lord, writ appeal against the judgment and order, lordships, which has been passed by the learned single judge, my lord, in terms of which, my lord, my writ application was dismissed, my lord. Lordships has come to 93, my lord.
Just.
No problem. Procedure memo के लिए आपका ना Is there no appellate tribunal for these matters?
Yes, Lordship, it is there. Lordship, we issued notice under 124. They have to file reply, then adjudicant authority has to adjudicate the matter. Thereafter, matter lies to the appellate authority. And thereafter, Lordship, matter lies to the CSET, Calcutta.
So
Thereafter,
he has straight away approached the High Court.
yes, he challenged the search and seizure law. In the meantime, we issued notice under section 24.
What
Lordship,
happened in
this
those
is-
proceedings?
Lordship,
What happened in those proceedings?
Lordship, that I have to take it.
Lordship, this is a case, my lord, where search and seizure has been done by the respondent authorities without there being jurisdiction, my lord. They do not have jurisdiction to exercise the search and seizure. This is our case, Lordships, and this is the reason, Lordships, that we have knocked the door of this honorable court under section 226
Why
of
the
the
learned single judge non-suited you?
Lordships. The learned singles judge, Lordships, learned single judge has held that, Lordships, that my lord, there were grounds for search and seizure, and Lordships, the learned single judge did not please it to quash the seizure, Lordship.
Come
In-
to para number 29
Lordship,
of the judgment.
Lordship. May I read, my lord?
Yeah.
The scope of challenging a so-called notice is very limited and circumscribed. Such challenge can be sustained only on fulfillment of certain conditions. For instance, few of such conditions can be lack of jurisdiction on to issue such notice, lack of competence, lack of bona fide, malafide exercise of powers, violation of the principles of natural justice. However, the aforesaid instances may not be exhaustive, and in a given case, such instance may be made out. But the objective of the court while dealing with such a challenge is that whether the person aggrieved has suffered any prejudice because of the same, and at the same time also have in mind as to whether the challenge is an attempt to preempt the authorities from taking any action in accordance with law. As stated, before issuing such so-called notice, the authorities must come to a subjective satisfaction and have reasons to believe regarding commission of an offense. Now, Lordships, as stated earlier, Lordships.
Next.
Yes, my lord. In the instant case, an attempt has been made on behalf of the petitioner to submit that there were no materials which can form reasons to believe, and in absence of such conditions precedent, the authorities do not assume the jurisdiction to proceed. However, a perusal of the materials would show that the impugned action is preceded by subjective satisfaction arrived at by the competent authority based upon information received regarding commission of an offense. The said condition precedent has also been substantiated by recovery of 800 bags of areca nuts, which have been stated to be of foreign Myanmar origin. Now, Lordships will see this the first two lines of paragraph 30, my lord. In the instant case, an attempt has been made on behalf of the petitioner to submit that there were no materials which can form reasons to believe, and in the absence of such conditions precedent, the authorities do not assume jurisdiction to proceed.
So the single judge,
Lordships,
for satisfying himself,
Lordships,
has gone through the material and a finding is recorded that
Lordship.
the authorities have subjective satisfaction.
Lordship,
to issue
this
the
finding, my
notice.
lord.
Then how far we can interfere in this?
Lordship, this finding of the learned single judge,
Yes.
that there is subjective satisfaction on the basis of which this seizure was done. This finding is an illegal finding, my lord.
Why?
The reason being so, my lord, that the mandate of law is this, my lord, that on the basis of objective considerations, search and seizure has to be done. On the basis of objective considerations, seizure has to be done.
Suppose there was some not objective or subjective satisfaction was there, and the search was conducted, and in the result some material of objectionable material was found, then also the court can even interfere.
Lordships, there has to be objective considerations, my lord. There are numerous judgments of the Honorable Apex Court, Lordships, which have held that in cases of section wherein powers under section 110 of the Customs Act are exercised, meaning thereby, my lord, when seizure is done in terms of section 110 of the Customs Act, the condition precedent on the basis of which such powers can be exercised is, lordships, that reasons to believe, the proper officer must have reasons to believe that these goods are liable for confiscation, my lord. Now, when the Honorable Apex Court, lordships, it has interpreted this term reasons to believe, it has stated, my lord, that these reasons to believe have to have its basis, lordships, on the basis of objective considerations. What the learned single judge, lordships, has held is that the proper officer have exercised his jurisdiction on the basis of subjective satisfaction. And lordships will peruse the materials, my lord.
को फाइनलाइज करने के
Now, this is of 14/9/2022. Thereafter, what happened? In that show cause notice proceedings, what happened?
In the so cause notice proceedings, my lord, lordships, we are not attending that so cause notice proceedings because
You are
of
not
the
attending,
lordships.
and they have decided it finally.
No, lordship, it has not been
Still
decided.
it is pending.
It's pending, lordship. It's pending. Nothing has happened in that proceeding. It is lying, lordship.
Lordship, regarding that, that is another authority. I have to obtain instruction, lordship, take up tomorrow, lordship.
Even though if those proceedings have culminated into final order,
No, lordship.
what remains
No,
in this?
no, lordship. It has not culminated.
They can pass an order ex parte also.
Lordship,
We are not
they can pass an order, lordship, but to my as per the instructions that I have received, my lord, those proceedings, nothing has happened, my lord.
And the appellant is not appeared before the authority, lordship.
Okay, what you have done then? If he has not appeared, whether you have decided, proceeded further or what?
Lordship may take up tomorrow. I'll obtain.
Okay,
Lordships,
learned counsel for the respondent, raise some time to apprise this court that pursuant to the show cause notice issued to the appellant, the proceedings initiated against him has been concluded or not, has been finally decided or not.
Slots.
Yes, show us. Let them confirm, then we'll hear.
That's right.
What about 17th?
Slots.
lordship says fixed on, my lord, which date, my lord?
17th.
May be on 19th, Monday.
Monday. Monday. Is it? Okay. Monday. No, sorry.
Item 30.
May it please the lordship.
Marketing करने के लिए
Meet the lordship.
Not by this order.
Well,
What?
Lord, when we filed the writ petition, Lord, there was an attempt by the authorities, Lord, to demolish, Lord, without any notice.
Right.
And we came before your lordship, Lord. During the pendency of the proceedings, Lord, the state authorities carried out an exercise, my Lord, in which we did not participate therein.
Right.
Lord, we are not allowed. Subsequently, the matter came up, my Lord, and my Lord, we raised the issue, my Lord, that since the notice has to be given, my Lord, it would be the National Highway Authority under the Highway Administration, Lord, who should ought to have been the Lord authority who should have issued us notice, Lord, would have a right to Lord raise our grievance in that. Lord, that contention of ours was not and a fresh exercise has to direction has been issued.
So
And
you are
Lord, the
agreeing
position,
by that no fresh exercise can be carried out.
my Lord.
And these technical objections noticed by such authority and such authority and such authority should be issued, and then only they can proceed further. This is what your contention is.
Yes, my Lord. And my Lord, because under the under the 2002 Act is the Highway Administration, my Lord, who is the authority who has entire documents and he is
Mr.
the custodian.
Concept, it's
My Lord.
an attempt to halt the construction of the national highway on your part. Admittedly, you are in excess of land, you are in possession of excess of land, and you are an encroacher. Despite that, if you are attempting to again halt this construction, this court is not supposed to interfere into the matter.
Lord,
Simply because that authority should have issued the notice and that authority should not have issued. What is this?
Lord, on both.
You are an encroacher.
Yes, I am
Your
encroacher,
encroachment
Lord.
has to be removed.
Lord, I am encroacher, Lord. There is no dispute as regard
And
to
still
that.
you have audacity to come before this court. Yes, I am encroacher and issue me a notice by so and so an authority, then I'll see. And
Lord,
you expect that we'll interfere in this matter.
my Lord, the authorities are not acting, Lord, in terms of law, Lord.
Or you being an encroacher,
my Lord.
very law-abiding citizen.
No, Lord, what has
You
happened
are
is
admitting.
no.
See the audacity, you are admitting,
Lord,
I am the encroacher,
Lord,
but let the so and so authority may issue a notice, then only I'll reply.
Lord,
What is this?
my contention for your lordship's consideration, this is this. Lord, the state authorities are not in the control of the land, Lord. It's the highway
Whatever it
administration.
may be, you
Lord,
are encroacher or not.
Lord, I am encroacher.
You-
Yes, yes.
Great.
Lord, I would like to rely upon one of the judgments of that.
Which judgment? The judgment says that even if the encroacher is there, interfere in
Lord,
that matter and grant him this
Lord, it is.
protection.
Lord, let me place the facts of this case.
कहाँ का judgment है sir?
Lord, apex court judgment, Lord.
Apex court.
Yes.
Okay, then approach the apex court.
My Lord, kindly for a
No.
moment consider this.
Sir,
Lord, in
that
this
relief
case,
can only be granted
my
by
Lord,
the apex court.
Lord, in this case, my Lord, there was a notice. In my case, I have not been given a notice. And my Lord, the state authorities under the 2000 Highway Act has given a notice, my Lord.
Mr. Concept,
My Lord.
Learned Single Judge has granted you indulgence, though there was a joint survey. You have not participated in that survey. The Learned Single Judge was kind enough to give you an opportunity कि okay, again do a joint survey involving the petitioners also and give us a report, and still you are agreeing.
My Lord, my grievance is, my Lord, the entire exercise has been done on the behest of the state authorities, not the highway administration, my Lord, who is the correct authority, my Lord, because he has the records. My Lord, he doesn't come, he's the circle officer.
Sir,
And
that-
both these
You
both
just
these occasions, my Lord, there is deviation in the measurement, my Lord. My factory is at the stake, my Lord.
read this
My Lord,
para number 14 from read para number 14.
my Lord. My Lord is,
Para number 14 of the judgment.
my Lord, which I am relying upon, my Lord.
Array, impugn judgment, sir.
Yes, yes. Before that, can I point out para 9, my lord, page 82 for a moment, if you lord,
Okay, read. Para 9
of the impugned judgment, page 82.
Fine.
In the backdrop of the above, let this court therefore take note of the respective contention of the parties. Mr. Dubey, the learned counsel opinion we have the petitioner submitted that if the petitioners are in occupation of any land which are required, the petition can only be disposed by following due process as per the procedure stipulated in the Act of 2002, and more particularly refer to Section 26 of the said Act of 2002, which provides the due procedure of law. It is therefore submission of the learned counsel on behalf of the petitioner that the state authorities have no business to demolish the boundary wall of the petitioner in the manner which has been sought to be done, and it is only the highway administration constituted under Section 3 of the Act of 2002 or officer authorized by the highway administration who can act as per the Act of 2002. He further submits the highway administration as per Section 23 of the Act of 2002 is also required to maintain record in the prescribed manner in respect of to all lands of central government. And it is on the basis of those records the highway administration or the officer authorized can act in terms of with Section 26 of the Act of 2002.
Again, read. How the learned single judge has dealt with it.
My lord. Now para 14, my lord. Be that as it may, this court, however, finds it relevant to take note also of the merits of the case in as much as the same would be necessary for the effective adjudication of the dispute. From the records available, it is clear that 2 bighas 2 katha of land belong to the petitioner. It has also been mentioned in the writ petition that on the said land, the petitioners have established their factory and a boundary wall was constructed. From a perusal of the affidavit filed by the respondent number 5, and more particularly the enclosure thereto clearly shows that 0.072 hectares with correspond to 2 katha 13.8 less of land was acquired under the provision of the National Highway Act. Therefore, the remaining land of the petitioner pursuant to the said acquisition would be 1 bigha 4 katha 6.2 lessons. From the communication issued by the petitioners to the circle officer dated so and so, it is an admitted fact that the petitioner is in possession of 2 bighas of land, which means that the petitioner are in possession of an excess land measuring 13.8 lessons. The petitioner have no right to the additional excess land which are in occupation of the petitioner. However, to identify the said land, there is a requirement of a demarcation. This court also duly taken note that there was a demarcation done on 13/9/2023, and during demarcation it was found that the petitioners had encroached 9 feet of land of NHAI in the southern side of the and 20 feet of the land in the northern side, and the boundary wall of the petitioner number 1 factory was situated so and so on the highway acquired land. This court also cannot be unmindful of the candid submission of so and so, the learned government advocate, that the circle officer Rangiya Revenue was not present during the joint verification carried out. Under certain circumstances, in order to identify the excess land measuring so and so, which belongs to the NHI pursuant to the acquisition of the matter, the entire plot of land measuring 2 katha so and so, which was acquired by the petitioner number 3, this court directs that the respondent authorities, more particularly the circle officer so and so, by himself along with the revenue officials to carry out the said demarcation and identify the said plot of land and take possession in terms of Section 3E of the National Highway Act and hand over the same to the National Highway Authority. The representatives of the National Highway Authority are directed to present on the date at the time fixed by this. So, my lord,
Yeah, again.
my lord, the said demarcation will be carried out on so and so. The petitioner are given liberty to participate in the said demarcation proceeding. This court further directs that while carrying out the said demarcation proceeding, the respondent authority shall also take into the account the maps prepared during the said acquisition proceedings. This court further makes it clear that if the petitioners participate in the said demarcation process, a copy of the demarcation report shall be furnished to them immediately upon the report being prepared.
What happened to that? You have not participated in that.
Next, subsequently, because your lordship has said that.
30th of November 2023, you participated?
Yes.
What happened in that?
My lord, there was, your lordship has directed that it should be carried out, but no possession or demolition should be done, my lord. I have an interim order in mind.
So still that has not been done.
Not done. And my lord,
You have participated in.
I participated.
What happened and what is the
My
result
lord,
of that?
there also, my lord, there is some deviations.
What deviation?
My lord, now the measurement is something different from what it has been originally.
Okay, so what's wrong in that?
My lord,
As per that demarcation, the encroachment, if there is encroachment, that will be removed. And if
my lord, the learned single judge, my lord, my respectful submission, my lord, I am raising a question of law before your lordship, my lord. My lord, even under the scheme of 2002 Act, my lord, there is a tribunal. If the highway authorities acted.
You're raising a question of law at the cost of risking of, you are risking a, order of cost that you may be mindful of. How many years you are in possession of this land?
Mulad, I have been, Mulad, more than 10 years, Mulad.
More than 10 years.
Yes.
So you are enjoying the land of the NHAI, acquired land from last 10 years. And still you are resisting, even the demarcation can't be done. Then you are at risk. And while considering all this, we'll consider all your arguments, but you are at risk of that we may impose a heavy cost upon.
Well, I'll bow down to your lordship's Mulad on that, Mulad. If,
Ready to pay the cost even?
Mulad, with due respect, Mulad, Mulad, my case is, Mulad,
Whatever it may be, whatever it is.
Mulad, my case is, Mulad, is the highway authorities. Mulad, tomorrow again this situation may arise because it's not the highway authorities who is giving me notice. And if at all I have a grievance, Mulad, I can raise it, Mulad, because they are maintaining the record. My lord will see.
Going marketing the character of the marketing. Yes, yes, there is an order. No, there is an order of the pendency, maybe the marketing process should go. There are photographs, no, to show that. Yeah. I was referring to this order.
You attended those demarcation proceedings?
My lord.
You were there in the at
Yes,
the
in the
time of demarcation
second one I was there, my lord.
on 30th of November.
Yes, yes, I was there,
2023.
my lord.
You are in these photographs. You have supplied him copy of demarcation.
But I have instructions that my authority was there on them. My lord, I can identify, my lord. One representative is there.
There, na?
Yes, yes.
You have any objection regarding this demarcation proceedings? You
My lord.
signed the, I think so, the proceeding.
Yes.
And this clearly says during demarcation, it was found that the petitioner has encroached over 2.5 meters of NHAI acquired land in the southern side and 4.8 meters of NHAI acquired land in the northern side, 45 6 meters land both sides, and the boundary wall of the petitioner is situated over NHAI acquired land. Is the fact?
My lord, it's a fact. My lord, what my apprehension is, my lord. My lord will see the earlier measurement done. My lord, it's by the same circle officer.
That's why only earlier measurement, you are not satisfied with that.
My lord,
You were not
My
satisfied.
lord, my
that-
case is, my lord,
That's why only the
My
learned
lord.
single judge granted indulgence and
that's true. My lord,
issue fresh direction.
my lord,
for
again they will come,
fresh
they may come, my lord.
demarcation.
My lord, again they may come, my lord.
How?
But it is the highway administration who has kept the record, my lord. I have not been shown the entire
Highway
map.
administration was also there, sir.
No, my lord.
Signature of NHAI
No, my lord.
officials.
My lord, highway administration is a different authority under the 2002 Act, my lord. If your lordship will kindly see. My lord will kindly see 2002 Act, my lord, for a moment, my lord.
We are hearing from last half an hour almost.
My lord.
We are hearing you from last half an hour almost.
Lord, just two provisions I want to show to your lordship.
Okay, sure. Yes.
The Control of National Highway Land and Traffic Act 2002, my lord. National Highway Act. Where is the Control of National Highway Land and Traffic Act, my lord, 2002?
You are referring to?
The Control of National Highway Act, Land and Traffic Act 2002, my lord.
Yes,
My lord.
2002.
Yes, yes, my lord.
Which provision?
Your lordship would see 2F, the definition it says, and then lordship would come to 3, my lord. This is the establishment, and then I'll directly come, my lord.
2F. Highway administration.
Yes, my lord.
Okay.
And 3 says, my lord, is the highway administration should be established, my lord. And it also says under M, my lord, unauthorized occupation.
Yes, 2F, you're referring to
2M.
highway?
2F and 2M, my lord, definition.
M.
Yes, my lord.
Yes.
Section 3 is the establishment of highway administration, my lord.
Unauthorized means any occupation on the highway land without permission under the act, which for such purpose by the person who is trespasser on the highway for the timing. Yes, why you are referring to this?
But because the jurisdiction of prevention of unauthorized occupation, my lord, is within this highway administration, lordship would see section 23.
Okay. Section?
23, my lord.
And what about section 3, establishment of
Yes, my
highway
lord.
administration?
In terms of this act, my lord, authority is established, who is called a highway administration, my lord, who has the jurisdiction under this act, my lord. And section 5 also speaks of, my lord, establishment of tribunals.
Just a minute. Yes.
My lord, will come to section 23, my lord.
Yes.
Highway land to be deemed to be the property of central government, my lord. And subsection 2, my lord, the highway administration shall cause to be maintained a record in the prescribed manner in which the particulars of the land relating to the highway to is the so and so and so so and so. Lord, so under the act, my lord, is the highway administration which maintains the records, my lord. And lordship would kindly take subsection 2 of section 26.
Yes.
When as a result of periodic inspection of highway land or otherwise the highway administration or the officer authorized by such administration in this behalf is satisfied that any unauthorized occupation has taken place on the highway land, the highway administration or the office so authorized shall serve a notice in the prescribed form on the person causing or responsible for such unauthorized occupation, requiring him to remove such unauthorized occupation and to restore such highway land in its original condition as before the unauthorized occupation within the period specified in the notice. So my grievance is, my lords,
Unauthorized occupation is somewhat else than the encroachment. Okay? Unauthorized occupation is something else than the encroachment. Here you are encroacher. You are not in occupation of the land.
my lord, 2M, your lordship would see, with I would come within the definition of 2M, my lord.
Whatever it may be.
For whatever
encroach-
exercise, my
okay,
lord, my lord, it's a
2M.
broad
Yes, read
exercise.
2M.
My lord, unauthorized occupation means any occupation on the highway land without permission under this act for such purpose by a person who is trespasser on the highway for the time being is paying or is liable to pay other person rent, leaves in or otherwise uses any premises on a highway. Even assuming, my lord, if I fall in 3,
So, are you claiming that this is not the land of highway?
no, my
You are
contention,
claiming this is the land, that
No,
this
no,
land
no,
doesn't belongs to highway?
no, what
You are
I'm,
not claiming.
no, my lord, why?
You are admitting the land is highway land.
Now, because what has transpired, my lord,
Just a
yes,
minute. You
yes,
are admitting this.
yes, yes, yes,
That land is highway land.
highway land, part of my land, my lord,
Part of land, yes, part of land.
yes, yes.
And then have you raised any claim at any point of time? Yes, sir, this is not your land and this is my land.
No, no,
As per section 20, the subsection 3 of section 23,
no, we have not raised, my lord.
any person claiming against the ownership of the central government referred to in subsection 2 shall make a written complaint to the highway administration to prove his claim before it, and the highway administration, after considering the evidence produced by such person, may correct such or record defect to the. You are not.
No.
So admittedly, you are encroacher over the land of highway administration.
Right.
Yeah, that's all. And now you are claiming that the notices should not be issued by the state government or the NHI officials and only by the highway authorities.
Right.
This is what your case is. Anything else?
My lord, I'm just relying on the judgment.
Yes. Read.
My lord, page number is at the bottom, my lord. For the facts, my lord, if your lordship is para 2. The
Yes.
appellant in this case filed writ petition wherein they mounted challenge to the so-called notices issued by the respondents. The High Court by the impugned judgment did not interfere with the impugned notices, noting that the appellants have not attributed any malefides and their writ petitions were accordingly dismissed. However, in paragraph 15, it has been held so and so. However, it will be open for the petitioner to offer their explanation to the impugned so-called notices to the respondent within period of 10 days from the date of receipt of copy of so and so, so and so, so and so. The dispute lies essentially in a narrow campus. The allegation raised in the so-called notices is to the effect that the appellants have encroached upon the property comprising of in the national highway in question. The case set up by the appellants before the High Court was that the notices have been issued purporting to be under section 28(2) of the Tamil Nadu State Highway Act. It was contended that the said enactment had become void in view of the enactment of the right to fair counsel, so and so, so and so. It was expatiated and it is contended that the authority under the state act did not have the jurisdiction in the matter of dealing with the alleged encroachments over the national highway. The High Court notices that though the road actually belongs to the National Highway Department, the construction and the maintenance of the road was under the supervision and control of the officer of the National Highway Wing, Highway Department, Government of Tamil Nadu. Noticing that since the subject matter of the road is under the maintenance and supervision of the National Highways Wing, Highway Department, Government of Tamil Nadu, the court did not find any error in the impugned notices. It is further noted that there were 326 encroachers in the said highway, and such encroachments were identified after survey and notices were issued. It was further observed that the impugned notices are only so-called notices which are normally not interfered with, except for lack of jurisdiction of the authority or if malafide is attributed. Accordingly, the writ petitions were dismissed as notices. In the appeals, the appellants persisted, para 4, my lord, with the complaint that the notices have been issued under State Act. It is the case of the appellant that the officer who had issued the notices could not possibly have seized at power to purport or remove the alleged encroachment in the national highway. The contention, of the other hand, of the state, as articulated by so and so, is that notification has been issued under Section 5 of the Highway Act of 56, and the roads in question where the encroachments have taken place are covered by the notification. It is the contention of the respondents that the officer, therefore, who has issued notices purportedly under the State Act did have jurisdiction as correctly found by the High Court. Now, my lord, will kindly come to page 4, my lord, para 8.
Para 8, para 12 पे आ
Where the, my lord, the provisions have been quoted, my lord.
Yes.
Para 12.
Come to para 12.
Yes, a perusal of section 26, bearing in mind the object with which the said law was enacted, leaves us in no manner of doubt that as regards the power and procedure for removal of any encroachment at a national highway, the appropriate law is the Act of 2002. In other words, the so-called notices which have been issued and impugned in these cases are admittedly issued seeking shelter under section 5 of the Act of 56. Power under section 5 of the Act of does not extend, as is made clear by the circumstances leading to the Act of 2002, and also the express provision of the Act of 2002, in particular section 26, which provides for the procedure as also the power for causing the removal of encroachment in regard to national highway. Section 14 of the Act of confer a right of appeal to the tribunal. The upshot of the above discussion is that the so-called notices, which have in fact been issued by the officer clutching the power under section 28 of the Act, and which the learned senior counsel of the state seeks to rest under the provisions of the notification issued under section 5 of the Act, are unauthorized. As correctly observed by the High Court, one of the grounds on which so-called notices can be interfered is with the lack of jurisdiction of the authority. This is one such case where the authority to take action and the law under which such action can be taken are all found located in the Act of 2002. To be more specific, the provision of section 26 provides the statutory character for setting in motion the proceedings to get rid of the encroachment over the national highway.
Where's the tribunal?
Let
Where's the tribunal?
the X provides for
Where is that?
section 14, my lord.
Section 14 is altogether different. Tribunal. Where is the tribunal? They learned that in this judgment,
My lord.
they referred to some tribunal, but that has already been repealed. That provisions regarding constitution of the tribunal and all, that has already been repealed.
No, my lord. Tribunal under the Act of 2002, my lord, it speaks.
Yes, 2002. Read.
Section 5, your lordship would see. Section 5, my lord.
I want to ask you, but क्या करेंगे? ये useless form. Useless form.
Yes.
My lord. Good. On similar facts, but I have a better case because no notice was issued to
A
me.
better case because you are admitting, yes, I am encroaching.
No, Lord, because no notice, but in
You
my
have a better
case, in my case, no notice has been issued. Lord, there is a
Mr.
purpose coming
Mr.
before.
Dubey, what is the prejudice caused to your client?
My lord, I may explain to your lordship.
Hmm.
Lord, the land is not, Lord, parallel to the national highway, Lord. Therefore, Lord, my shed comes in the way. Lord, there is a boundary wall which would be demolished anyway. Lord, by the side of that, Lord, I have a shed of a factory. What has happened, Lord? That the entire acquisition proceeding has taken place in 2012, somewhere that. Lord, they have never raised, we were also not aware. All of a sudden, when the authorities came for demolition, we moved your lordships, saying that at least notice would be issued, so that we also come to know, Lord, that to what portion, Lord, we have to give up, Lord.
In fact, they were in requirement of the land now for widening of the national
Yes,
highway.
there is a
Otherwise, it was earlier
Lord,
going
Lord, I am
on.
not on that. Lord, if they don't do it, my Lord will see that two different measurements would affect me adversely in the manner that my factory would also go, Lord. In one way, Lord, it's been saved. In the other, it's not been saved.
Which other, this joint inspection latest,
My Lord,
in your presence, you have not filed any objection against it.
my Lord,
So,
my Lord, my submission for your lordship's consideration is, your lordship would see, I have raised the point. They said that highway administration was not a party because it's a different than the, Lord, and the direction has been issued under section 3 of the 56 Act, my Lord, which is not applicable, which is only applicable, my Lord, at the time of the initial acquisition.
yes.
May I please, your lordship, I am appearing on behalf of NSA. First, I'll raise one point what he is raising so far. According to him, he is asking that this provision would have been under provision of section 26 of Act 2002, which is mentioning. Here, that the lordship has definition also has been read where in section 3. The administrator is the power in that section I'm telling you for. My learned friend, I have raised my affidavit also in that point was taken. How much honest thing the administrator was not paid party. Even lordship will be judgment itself, which a party which has made me, that is National Highway, even showing not proper address also. Still, I have replied to this because he has submitted some material fact. Whatever amount has been taken, he has never been there. This has been discussed by the Honorable Single Judge Miller. Only I'll trouble your lordship going to only per I like it. That must. Here I'll read my paragraph.
You just
See, hear me, Lord, he is not made party. We are not being made party. By way of filing affidavit is
National
applying.
Highway has not been implemented as party.
National Highway is party lordship. That is what I'm telling. That is how he's making party. Still, lordship will get it. Here, National Highway Party Millard. Last paragraph. National Highway Authority represented by General Manager P. Tezpur. Whereas this address is wrong. We are not in Tezpur side. We are not at all constructing this route. This is supposed to be project director of Guwahati. Still, we are filing in this one. And regarding administrator, there is a notification, my lord, clear notification for central government. Who will be the administrator? Particularly, that notification is clearly said, my lord, this one, in the, it is issued by Government of India, Ministry of Road Transport, Highways, National Office, Civil, this in Guwahati, it is for who will be the administrator for particular 2002 Act, my lord. Here it is clearly mentioned. I'll forward to this letter to your lordship also after reading. Here 36 CL number, it is saying project director, NSI project implementation Guwahati. This particular area, project director, PIU Guwahati, project implementation Guwahati. He knows the things, assuming fit, taking on that. He has never met party. By your affidavit in reply, he wanted to bring by this one. Even once you know, for time being, I'm saying we were going apart. You are not making a proper party itself, who are required to be a party, you are not making party. Now you are telling the administrator should come, section 26 should come on 2002 Act. How will come? You are not making party. You have not made a party. This has been raised before Honorable Chingu Judge. In spite of that, my lord, Honorable Chingu Judge, because I there also, Honorable Chingu Judge, lastly, one line is there, one paragraph. this writ petition might have dismissed, but keeping the interest here, it is clearly mentioned, my lord, it might have gone to, that word is there. This here, paragraph 13, it is saying, it is opinion of this court that writ petition would have been dismissed on the ground of suppression of material fact itself, because he has never disclosed regarding procedure, what has been adopted during acquirement. This is TA, TD notification. Even he has not mentioned nowhere that he had accepted some amount for that. He never. But still, honorable court wanted to go for answer of justice, finalize the things so that should not come. Now, my lord, he's insisting on this point. And rightly, it has been his enforcer. He admitting before lordship is enforcer. It is our land. For assuming my lord not admitting, suppose according to his proposition that if we suppose your notice, same thing will serve us, same will be governed, my lord, will come by same, because it is in front of it, it been, the measurement was given, everything is admitting. Suppose we, as lordship is passing, for allowing to issue notice on that, the same will come out, my lord. The wastage of time of this honorable court, my lord. What will come? Nothing will be progressed, because it is in front of him, assessment was carried out, my lord. This is my humble submit. This petition would have been dismissed by Honorable Chingujwat, but anyhow allowed, my lord, and now before lordship empty. May allow me to, partly, that is your
Now,
lordship.
what about this, his argument?
My lord.
This notices of the proceedings for removal of the encroachment can be initiated at the instance of the National Highway Authority or the state authorities. Only highway administration can do it.
Yes, that's what I'm telling you, lord. That would have been, that point would have come before single judge. That is a need petition.
He has not raised.
He has not raised, he has not made party itself, my lord. Administrator has not made
Even
party.
in this writ petition, there is no such ground.
By affidavit, when he has participated, everything is procedure, then by way of affidavit reply, he has raised this question. Okay, fine, this one.
So do you have any answer to this question?
Which question? Yes.
Yes.
Yes, we have not issued any notice on this, our stand.
Then
We-
who has issued the note?
That is measurement is done by the state and revenue authorities, my lord. So that was done by carried out by the only I was made party on National Highway Authority, but apart from this one, I have submitted my affidavit because he has not disclosed all the things regarding TA notification or TD notification and TG by which he has received amount for compensation. This has not been disclosed.
Whether the state has issued any notice to him for removal of the encroachments?
This they will
Yes.
get my yes.
My lord, may I please? The state authority, the revenue authority, the circle officer, he has done according to the direction of this honorable single judge, because the honorable single judge directed him to make a demarcation. Accordingly, he did it. In presence of both the representative of the petitioners as well as.
What was the occasion for him to approach this court?
My lord.
What he said, the state administration is removing this my boundary wall and something, whatever I constructed there.
No,
What
my
is their
lord.
objection?
No, my lord, no, my lord.
So who was removing that?
Removing, my lord, that question of this national highway, this is their land. We have already acquired the land, handed over the land to the National Highway Authority. Our part is over. But as per direction of the honorable court, we have done the demarcation.
Oh, that's right. You are in the position of this excess land since when?
My lord, 2012, my lord.
2012.
12. Well, just I give one background in 1 minute, my lord. What has happened, my lord?
We are asking first.
Yes, yes. My lord, why this
What
has,
is where the land is situated on the national highway?
yes,
Approx rate of the land is?
my lord, present rate, my lord. It would be around 20 to 30 lakhs per bigha or more also. my lord.
20 to 30 lakhs per bigha.
Bigha, yes.
The almost half of the bigger of land is in your possession.
18 less, 18 lesser, my lord.
18 lecha.
Yes. 13.8.
Part less than 1. Please let me. We are just calculating for the purpose of imposition of cost. Kitni lagji, how much cost we can impose upon. For that purpose, we are. That's all.
Only one clarification, Lord. My friend is.
Still you have a chance.
My lord.
Still you have a chance. Accept this demarcation proceedings and remove the encroachments. Otherwise, will pass certain observations and that may prejudice.
Why don't you remove it yourself?
I'll remove. My predicament is this, my lord. Your lordship would see when I approach your lordships, no notices were issued to me, either from the state, my lord, I was not aware. Therefore, my lord, let then.
What my brother is suggesting.
My lord, I bow down to your lordship what suggestion has come, Lord. But what I'm submitting, Lord, if then my lord will see in both these measurements there are differences. So if they say that this would be final, my lord, then we will do it ourselves.
The last one is final as per the court order. This is the final.
Then, my lord, the highway authorities may never raise any question as regard that, my lord.
We don't know if anytime if they'll raise any question, you have a order of this court in your favor. That he has already removed the encroachments as per this measurement. See to it. If any time they'll come, remove it by today, tomorrow will come. Otherwise, be ready for a heavy costs.
Then lordship may give us 1 week's time, my lord, because
Not 1
it's
week.
a boundary wall, my lord.
Not at all 1 week, sir.
My lord, it's a boundary wall, my lord, of the factory, and my lord, I have.
File an affidavit of this effect. They will remove within a week.
Yes, my lord, that we may do.
As per this new demarcation.
My lord.
This.
My lord, the new
demarcation. File an affidavit by tomorrow.
It would be.
Mr. Consul for NHA, you are ready for this? You are agreeing with this? Whatever the demarcation proceedings on November 2020.
Because though my friend has not given, I may say because my living is present there.
Yeah.
That is why now I cannot object also to that, but I have not, I'll get pick copy now. Not morally, I should not.
We are listing it tomorrow.
My lord.
File an affidavit. Yes, you are ready to remove the encroachments as per this new demarcation order. That's all. Otherwise, we'll close the order for.
My lord, affidavit will file my tomorrow. Lordship can take this on 15 minutes. Tomorrow I am out of session, Lord. That's my difficulty.
We have heard the learned concept of the. Undertaking. We have heard the learned counsel for the parties at length. During the course of the argument, learned counsel for the appellant submitted that he would file an affidavit of the appellants while undertaking that the encroachment over the national highway land would be removed by the appellants on their own as per the demarcation exercise carried out by the joint team of revenue officials, NHA officials, dated 30th of November 2023. Stop. Learned counsel for the appellant prays for and granted 2 days time to file affidavit of the appellant of this effect. List on 15.
My lord. deep table.
Item 31.
Next, please, your lordship. See the interpret appeal filed by the State of Assam Higher Education Department, lordship, against the Honorable Single Judge Order at lordship 7/12/2023, lordship, passed in 6/1/4 within page number 17 to lordship 23, where Honorable appeal by state notice. State normally appeal नहीं करता. But maybe isn't it meditated? I just don't know. I don't think so.
Notice to the response returnable on so and so. Returnable 3 weeks, returnable in 4 weeks.
Lordship, I have pair for stay, lordship, the
What
implement of
stay?
lordship.
What's the direction by the learned?
Direction by the learned single judge is that lordship, the respondent herein should be considered under the struck down act for provincial. Although we have provincial is servicing.
Said clarification that is directed to do the needful provision after the act of compliance of the writ petition. The requirement by done within a period of 3 months from the date of receipt of copy of this order. Now, this order is of 7/12/2023.
Lordship, already his service was provincialized under the 2018 Act. Lordship. It is not a fact that he was not provincialized, lordship. Otherwise, my lord, single judge, honorable single judge direction is that, lordship. We have to consider him in the struck down act, lordship, from the date of lordship.
Get the notices out,
Lordship.
then only wait. Pass an order on interim the application.
My lord may indicate that part, lordship, then.
That can't be indicated. Please.
I may be notice. Notice.
Issue notice of the writ appeal as well as the IA returnable to the respondents, returnable on so and so. You want to take this day or what?
Lordship, I will buy registered post, lordship.
The notices be sent to.
Huh?
There's no IA.
You don't want to stay?
Lordship, stay in a interim parish there, lordship.
Repair in the
Lordship,
application.
we'll fight.
No, only notices to the appeal, returnable on so and so, registered post.
Oblige, lordship.
Item 32.
Then appear this after 10 days.
Item 34.
In this case, my lord, an affidavit was reported filed by us, my lord. That was being filed on today, my lord.
You filed the affidavit?
Yes, sir. Today I am, it is being filed, my lord. We have not. Today it is being filed, my lord.
He is filing.
I am filing.
I have taken a copy, Lord,
You are in receipt of a copy.
copy of the reply.
Oblige.
Item 36.
May I please, your lordship. Lordship, this matter was to be argued by my senior, Mr. M. H. Ahmed, but due to his personal problem, lordship, he, sorry. Obliged, lordship.
Item 37.
Your lordship, my lord.
Here in this case, my lord, the other side has taken time to file affidavit, but no affidavit is not yet filed, my lord.
Who is to file affidavit?
My lord, this state government, my lord. Hmm? The last order, my lord, on 7/11/2023. Individually, public sorry. Read one of the channel that so basically, a division bench of PI.
How many petitioners are there?
My lord, here, my lord, there are six
Six
petitioners hailing from same
You are
village.
essentially you are aggrieved by
My lord, we are
by
agreed.
inclusion of your vote in the
Yes, my lord.
voter list of municipal act.
My lord, earlier we are in the, we are under Gao Panchayat. Without hearing their objection, my lord, they are included in the town committee, my lord.
That is a mechanism of inclusion and exclusion of names of the voters in the voter list. If any person is aggrieved by the inclusion or exclusion,
My
he
lord.
has the right to challenge the same further. That is there.
My lord.
ये गांव पंचायत area of the municipal corporation area में है. Without hearing objections under section 17 municipal act. पहले ये गांव पंचायत
Lordship, Lordship, by notification dated 11 August 2020, Lordship, objections were sought, Lordship, and thereafter that was rearranged.
You are for the state.
No, Lordship, I am for the Kharupeta municipal book, Lordship. I am for the respondent 7. Government is the appropriate authority, but
You mean to say that the procedure has been followed?
yes, Lordship.
So file your reply. You want you file your reply that this procedure has already followed.
But respondent is the appropriate, government is the appropriate authority.
Who is the government? Mr. You are for the government. Why you are not filing reply? Notices have already been. When?
That's the only given.
Mr. Council, we have doubt about this maintainability of PIL. It's an individual right.
My lord, the all entire village is affected, my lord.
They have not.
Oh, maybe.
But they
entire
all
village-
cannot come, my lord.
And out of entire village, only 5% have approached this court.
My lord.
Then only 5% are agreed by the majority of the people are satisfied that if they are included in the municipal town,
My lord,
only 5% have come.
my lord,
And Lordship, they
Either
have
you
not.
go ask that you have
My lord,
filed this
my lord, we
petition on
have-
behalf of the entire villagers.
And
My
Lordship, they have not challenged the inclusion of final notification, Lordship.
my lord, we
There is
have
no
represented, the
pair.
villagers have represented before the deputy commissioner. My lord, annexer 3, that says
They
that
have
out of
164 persons have represented, my lord.
Out of 1,300 people, only 4% have
My
approved
lord.
this court. It means only 4 are in objection,
My
otherwise
lord,
all are in agreement.
Others, my lord, the, my lord, coming to high court, my lord, this,
So
my
that
lord,
can't be
requires,
for the purpose of
requires
their
money, my
ascertaining
lord,
their rights, they have
expenses,
to
my lord.
approach the court, sir.
The villagers, entire villagers have represented.
You are for the
Response
Mr.
happened.
State Council. You are appearing for whom? All the respondents of the state.
I am.
You should come in forward and say कि reply file करना है sir. File your objection, sir. File your objection. Otherwise, without there being an objection, how will the consent for the
Department of Panchayat and Rural Department. Why you are sitting when the case is called, you should, if you want to file reply, you say. For the statement and concern for the respondent number 7 place for and granted time to file counter to the writ petition, time paid for is granted, list on so and so.
Obliged. Obliged, Lord.
Item 38.
Yes, His Lordship. My lord, we have challenged the impugned order of the learned single judge. We have challenged the order of the learned single judge, page 73, my lord.
73.
Yes. Now, Lordship would say here, the concerned school, Gunai Pani Ami Madrasa, was established in the year 1994, my lord.
Dated 5/4/2023. Impugned order is dated 5th of
Yes, 5/4/23. Page 76.
5th of April 2023.
Yes.
Yes.
Page 76. Now, my lord, here, some pertinent questions are to be noted here. My lord, since the year 1994 till the year 2023, all the reports were in our favor. That means in favor of the present appellant's school. But there was one inquiry report conducted by one CRCC. And that report is also doubtful. Report was, he made the inquiry report on 26, but it was forwarded on 24. That means 2 days before inquiry. So, my lord, we have 33 documents. And those documents, Lordship may kindly see, our 33 documents during the inquiry, we have placed before the inquiry officer, but those documents were not considered at all and passed the order in a manner with that also not given. There was no date, my lord. There was no date in the said inquiry report. That Lordship may kindly see the inquiry report, page 68, my lord. Lordship would say, here everything is doubtful. Page 72 is the signature of the inquiry officer. Page 72. Here is no date. Nor the inquiry report was furnished to us. And all along, my lord, there was order
When I be entered it will just there इंक्वायरी रिपोर्ट आया तो कुछ दोबारा ये पैरा 20 मिनट
Over a moment, Lordship may kindly see page 67. These are the documents I produced before the inquiry officer, but they could not produce any document excepting one false inquiry report. Kindly see page 67, ma'am. For a moment.
Yes.
Page 67, bank passbook of Allahabad Bank, so-and-so of my school, the appellant school, bank passbook, land deed, land namjari copy, land possession certificate, border area certificate, trace map, kacha patta, chitha copy, land deed, land trace map, land holding certificate, opening permission, recognition letter, letter of Gunaipani Himadasa dated 23/2009, letter of Sirakuti GPP, Gaupan Seth President. So BOS letter, Block Elementary Education Officer's letter, police report, FIR because my lord, she stole some papers from the school and opened a false school. And that's why department inquired the matter and asked to take strong action against him. But though no action was taken. Then Lordship, all these 33 documents were presented before the inquiry officer. But he only produced one document. Lordship, now kindly see his document, page 59. Kindly see the district elementary education officer, a district mission coordinator, Thubri, dated 24/6/2014, madam. Page 59. So on 24/6/2014, he addressed this letter to the DO. And he prepared the inquiry report on 26. Can you see now page 60? He prepared the report on 26/6/2014, but it was submitted on 24/6/2014. That means before 2 days. And the inquiry officer also did not push the date. So these are the things. Now, my lord, there are so many orders that action should be taken against respondent number 7, 8, and 9, who are the private respondents. For a moment, Lordship, kindly see page 47, madam.
इनमें जो कौन सा मटर है ये तो रेट को क्या
47, 47, 48, 53, 56. All are the high-level officers' order that he has prepared false document.
Mr. Conte, it appears that initially you filed a writ petition in the year 2011.
Yes.
That writ petition came to be dismissed.
No, that was dismissed, but we are given liberty to approach the authority.
And what was the observation of the at the time of the learned single judge in the year 2011?
It was perhaps 2014, perhaps.
2011, sir. Your writ petition was dismissed on 24/10/2011. . The learned single judge is observed in para number 5. This court-wide order dated 24/10 was dismissed writ petition number how it gave liberty to the petitioner to take recourse of appropriate provisions of law to remedy its grievance regarding the question as to whether the petitioner number 2 madrasa is the appropriate madrasa to receive.
Yes.
So, as the question required taking evidence and making of inquiry, this court held that the remedy of the petitioner number 2 lay in instituting an appropriate suit for declaration and is required for consequential relief of injunction. This court thus held that the writ court could not determine disputed questions of fact.
No, madam. I have answered to that, my lord. When I have so strong case, such a strong case I am having.
To whom?
My case is so strong, 33 documents.
Once the court has refused to grant
No,
indulgence.
that is why I am before your lordship, my lord. Court has,
And observed that you should file a suit for that purpose.
no, my lord, there,
Then why you approach this court
what
again?
is my humble understanding is this, my lord. When I have so many documents, and entire department is saying that legal action should be taken against them. For a moment, I have already requested your lordship kindly see the order of the government, page 47, 48.
Why? Once this.
No
court
action
has-
was taken.
In the year 2011, your writ petition was dismissed.
Dismissed, but with some observations.
Observation what? They have said, "Okay, approach the civil court."
No, civil court, thereafter many things happen well.
Thereafter, many things you may have done hundreds of them.
There was inquiry was conducted in my favor and it was established during the inquiry that his school is fake.
We have no doubts. This court has no, can't evaluate on the basis of this, the affidavit versus affidavit and some documents. You have to get your
My
rights
lord,
settled by the civil court.
The Honorable Apex Court has said
Yeah.
in many cases
Yeah.
that party should not be dragged to civil court when he has a strong case. I have a strong case here, they have no case.
Only on the basis of
Kindly
affidavit
see, my lord,
versus
they are,
affidavit and documents versus documents.
my lord,
it's
they
very
have filed
difficult
affidavit.
for us to analyze.
Lordship,
that
kindly
it is
let
the
me satisfy
genuine
your
authority
lordship.
to get the assistance.
They have filed affidavit. Kindly see what is in their affidavit. Nothing is there. And I have 33 documents from the very beginning till today, my lord. So they will approach, my lord. My lord, that is my prayer, my only prayer, understanding is this. When a person has many better documents, why he should go to approach the civil court? It is the other party. We have no document.
You should have raised this question when your writ petition was dismissed initially in the year 2011.
2011, my lord.
Why you have not raised this?
At that time,
Then you
my lord,
delegated to move complaints and then some report is there and again you approach this court.
my lord,
And
for
it's an
a
amending
moment,
process.
lordship, my lord, for a moment.
If you would have filed in the year 2011 a civil suit, it would have been decided by then, by now.
That is true.
आपने यहाँ पे writs में you have come again in the writs.
My lord,
writs and
my
then
lord, what is my understanding is this, my lord. When at that time these reports were not there, these reports came later on
reports were
against them. If your lordship is on that, my lord,
Okay, yes.
if your lordship is on that,
मेरे पास document था ये था inquiry का filing गलत है.
Yes.
if your lordship is on that, then I should go to the appropriate, there is tribunal, education tribunal is there. So that may be or not, civil court is, I do not know why
Whatever the authority, whatever the authority.
a tribunal,
if you want-
education
if you
tribunal
want-
is the authority
if you-
nowadays.
If you want any declaration in your favor that you are the genuine, this madrasa or the other is not the, to receive the financial assistance or best suited for that, you approach the appropriate authority. This court can't.
And given liberty to approve the tribunal, there are disputed questions of fact. If he approaches, tribunal will decide the case on its own merit without being.
Yes, my lord.
Mr. Madhumdar,
Yes.
tribunals are there, education tribunals.
Yes, tribunals
Let him
are-
go there. agitate his grievance.
A timetable may kindly be fixed, my lord, because we are suffering since
Sir,
1993.
Tribunal is
That's
sitting
lordship.
idle. The tribunal is sitting idle.
No, it is sitting.
Idle.
Functioning.
If it's sitting idle,
Functioning
we'll ask you to fix
No,
the matter on day-to-day basis.
Because
If
since
there are
90
so many pendency of the, we are not aware about that. How can we give a direction to the tribunal? Even if the Honorable Supreme Court many a times gives us a direction, we decide this case in within so and so time, and we have not been able
it
to
is
do that.
established in there 2017, so there is no rush of cases now.
That's right. Then we'll say expeditious.
Yes.
After attempting to argue the matter for quite some time, Learned Counsel for the appellant has submitted that he may be permitted to withdraw the writ petition with liberty to the appellants to approach the appropriate tribunal for the purpose for redressing for redressing their grievances. Full stop. Learned Counsel for the respondent has no objection if such liberty is granted. In such circumstances, this writ appeal is dismissed as withdrawn with liberty to the appellants to approach the appropriate tribunal for redressal of their grievances. If it is expected that the proceedings initiated at the instance of the appellants before the tribunal shall be decided expeditiously.
But there is one humble prayer. Instead of the word dismissal, it may carry a wrong message. It may be disposed of or closed.
Sir, it's dismissed is the only word, and we have given so many directions in 3-4 lines, so nobody will look into it. Ultimately, if you are withdrawing, then we'll dismiss it, or what else we'll do. It's nothing, sir.
Will not be influenced by the finding of that.
It is made clear that any observations made by the learned single judge in the impugned order will not come in the way. It is made clear that the tribunal shall not be influenced by any observations made by the learned single judge in the impugned order, and the claim of the appellants would be decided on its own merits.
Item 39.
May I please your lordship? Lordship, kindly pass over the matter for time being.
For the time being.
Yes, lordship. My
may-
senior is on record.
May I, my lord? My lord, this matter has been come under the column of affidavit, no reply has been filed. My lord, in my lord, earlier set of litigation, my lord, I am appearing for on behalf of higher
There is
education.
no requirement of filing
We'll be
reply.
relying on the affidavit filed in the before the single judge, my lord. So that may be fixed for hearing, my lord.
Is informed that pleadings are complete, so let this petition be listed in the admission notice served category. Yes.
Listen for hearing.
Yes, yes,
Been
yes,
admitted.
yes.
It has already been admitted.
Admitted, my lord.
Yes, sir.
Admitted
Hearing
notice, yes.
in due course.
My lord.
Appeal, huh? Appeal. bill.
Item 43.
May I please your lordship? This matter was earlier in single bench lordship. I'm very sorry to say lordship, we need some more time to file affidavit lordship. Earlier, we have taken time in single bench lordship.
Thank you. Okay. So, Mr. Pro, appearing on behalf of the respondent,
Respondent 1, 2, and 3.
1, 2, and 3, place some more time to file reply to the counter to the contempt petition. It is what?
It's a read
Read
petition, lordship.
petition lordship.
Petition.
2 weeks and lordship.
Lordship some more, 3 weeks lordship at least. If we have sent the copy lordship.
Okay, after list after 3 weeks.
Deeply,
Highly object.
deeply.
Item 44 to 46.
May it be, your lordship. If you over here, the state respondents have filed affidavit, lordship. Our reply is also ready, getting ready. So I have some clarification from my client. Let the matter come up after 3 weeks, lordship. In the meantime, I will file the reply, lordship.
At the request of learned counsel for the petitioner, place this matter on After 3 weeks.
Item 51.
Lordship, in this case, the pleadings are completed. Lordship may kindly fix for final disposal and the admissions.
Yes.
I appear for the governing body of the college, my lord. Response number 4.
So what is the grievance?
Lordship, grievance, here is Lordship, here are some, in the particular college. There are some fiscal mismanagement, Lordship, and I have obtained the audit report through RTI. And that amount, Lordship, amount of rupees 16 lakh 72,000 was defalcated. That was not submitted before the government. And Lordship, there is an inquiry, Lordship, pursuant to this honorable court's order.
Yes.
Lordship, fixing of hearings.
This has been admitted. Writ appeal has been admitted. Which order?
It is yet to be admitted, Lordship.
This is a BIL.
It's a
Yeah,
PL.
Lordship.
I've raised the issue of maintainability here. Because in the wish of espousing public interest, in fact, telling the appointments of respondent number 6.
Who is the respondent number 6?
He was ex-principal of research principal already retired.
Principal cum secretary
Lordship.
of the government body.
No, that is only a part, Lordship. Partly. My main grievance is with regard to.
But there is so many statements made in the repetition, Lord.
I have given.
Also kindly peruse and paragraph 8, 13 and 16, my lord. And in fact, they annex the appointment letter of respondent 6, as well as prayer also made for some.
Where is the prayer clause? The application.
Lordship, kindly turn to page paragraph 18. Kindly may read, my lord.
The written nature of the past illegal activities of the respondent was immediately placing under suspension to honor the truth and revive the institution. Independent investigation, CBI or SIT in affairs of national the bit of measure with regard to the utilization of funds, appropriate order, reveal the increasing activities and. But there, yes, there is a, but ultimately the large.
Lordship, but in fact, this PL is not at all maintainable against the respondent 6.
Public interest.
Who are you?
Lordship, I am a social worker, Lordship.
Social?
Social worker, Lordship.
So, you are challenging the, whatever the affairs of the college. Concern. How many colleges, the affairs of how many colleges you have challenged in there?
Lordship, only one college.
Why? Oh, there is only irregularity in one college.
Because Lordship, in this particular Lordship, in terms of the honorable court's order, there is already an inquiry.
You are a social activist and opposing the cause of the public at large.
Lordship.
How many public interest petitions espousing the cause of the public you have filed till date?
Lordship, that instruction I cannot have.
Oh, what instruction, sir? It's a purely you are raising concern about some irregularities in particular college.
Yes.
How it's a public interest, public at large, how the public at large is going to be affected by that, sir?
Lordship, may kindly see the inquiry, Lordship, the inquiry report.
What was the inquiry report, sir? It's in relation to only one college. The public interest should be in the interest of all of the state or the nation. You can't have this in one particular college, there is some irregularity. Why you not approach the authorities concerned by filing a criminal complaint?
Lordship, in fact, Lordship, after filing.
We can't extend the scope of this court to a particular college itself. Sir, there are thousands of colleges in the state.
Yes, Lordship.
And every person may come here tomorrow. This college is going on. We are going to entertain the writ petitions as public interest.
Lordship, this honorable court earlier after going through this record, Lordship, has
directed the department to make an inquiry. And that inquiry report has been filed by way of an affidavit, Lordship. Lordship may kindly see that in the inquiry, Lordship, it has been admitted.
Students, guardians. Of that particular body.
We have doubt about your bona fides, sir.
Lordship, in fact, Lordship, the allegation of misappropriation of money.
The petitioner, who is an active social worker, had tried to represent the students, guardian of the students in R.K. Nagar College, particularly the student community and people at large who are not able to enforce their fundamental and legal right on account of their incapacity, perversity, and ignorance of law. The petitioner desired to represent the voice of
Lordship, if
common people who is working welfare, sir, show us how many petitions and how many issues you have raised with the administration.
Yes, Lordship may kindly come to, yes.
In the interest of public at large.
Lordship may kindly come to page 22, for a moment, Lordship. Page 22, Lordship. That is the additional note of the audit report, Lordship. And it has, on the basis of this, Lordship.
22.
Page 22, Lordship. Lordship, para 2, Lordship, non-remittance of admission fees, tuition fees to government. In scrutiny of the records revealed that an amount of rupees 16,72,000 only were collected from a student as admission fees, tuition fees during the period from 147 to so and so, but the same was not remitted to the government. On query, the college authority stated that no fees were remitted to the government account as no instruction was received from the higher authority in this regard after provincialization of the college. So this entire amount has been defalcated by the authority of the college authority.
That is what
Yes, they are.
If that is not remitted to the state government, that is a grievance of the state government. How you are agreeing?
That is why, Lordship.
How you are agreeing? The state will recover or whatever it may be. They initiate the proceedings against them.
Now, Lordship, already an inquiry has been made, Lordship. Lordship may kindly see the inquiry report submitted by the Lordship, the Director of Higher Education by way of an affidavit.
You show us, give us an affidavit. How many this public issues you have raised at what level? You can't entertain in this manner, sir, PIL, any person. What is your interest in this college?
Because earlier I was a governing body member, Lordship.
Governing
body member.
That's why only. So
No,
it's a
now
internal politics and
I'm no
nothing
longer
else.
there.
You are a governing body member of this college.
On earlier occasion.
On earlier occasion.
In his tenure, this report was placed before the governing body, but at that time, he did not awake up. And moment I joined as a principal or in charge of the college, then he challenged my appointment. Lordship, kindly have a look at paragraph 8, entire appointment of my respondent 6 has been challenged here. Even interim pair is that I should be. Lordship, the inquiry report has proved whatever allegations
We have serious doubts about your bona fides.
Lordship, there are
Serious doubts about your bona fide and
in this particular college, Lordship, there are umpteen number of conversion of posts. All the things I have brought on record. And there's an inquiry, Lordship. If your Lordship goes by the inquiry report, Lordship, it has been proved. Whatever allegation I have made in this PIL, this has been proved, Lordship. They have not deposited the amount in the government account, Lordship.
to bring those judgments of the Honorable Supreme Court.
Lordship,
There are a number of judgments of the Honorable Supreme Court.
Lordship, in case in Jurisdiction Sahu case, my lord, court has held that PIL in service matter is not. No, this is not
Even
an
High
service
Court
matter. Lordship, why you challenging my
Yes, because
appointment?
it was during her tenure, Lordship.
Where? No, my lord. I just served the college as principal for a period of 9 months. Whereas this entire allegation is pertain to 2001 to.
Seek instructions from your client.
Lordship.
You can raise your whatever your grievance to the concerned authorities, or if you are having any grievance regarding that they have misappropriated the fund or all, you go and approach the police or whatever the authority may be. This PIL we are not going to interfere.
Then Lordship, the higher authority has already made an inquiry. So Lordship may kindly take into account.
In accordance with law, sir. You can't.
Yes, Lordship will.
At least
we are satisfied, this is not a public interest litigation.
Lordship, the findings of the inquiry
You
report
may, if you have any remedy, you may avail that remedy by way of filing writ or whatever in the proceedings. Not this, public interest, we are not.
Lordship, I only pray for that logical conclusion may be made in terms of the inquiry.
Conclusion, this is not the only authority which you can, where you can pray for this logical conclusion and all. You can go and avail your remedy before the appropriate forum, sir. Not in this manner in the PIL. Get your matter settled. If you have any grievance, you may file a writ petition before the land single judgment. Not in PIL.
Lordship, this inquiry has,
jurisdiction, sir.
this inquiry has been made only in terms of the division bench order, Lordship, on the earlier occasion, Lordship.
What was it?
And that inquiry report has already been brought on record by
Again, you have approached this court division bench.
no, this honorable case as part on the last occasion, Lordship.
Okay, we'll hear you about the bona fides and the maintenance of the petition on the next date of.
Lord.
Okay. This matter for hearing on 6th of March regarding the maintainability of this writ petition as public interest in the public interest and regarding the bona fides of the petition.
My lord, one humble prayer, my lord. Can it be on any other day other than 6 March, my lord? Some inconvenience, any other day.
You all fix fourth.
Fourth.
No, sorry. Yeah, 4th of March.
4th of March.
Lordship, high level.
Item 52.
May it please, Lord. My lord, this PIL, my lord, was regarding non-completion of the, my lord, diffuse sports complex, my lord. For the moment, if your lordship come to page 103, page 103, this is under the Ministry of Donor, my lord, Development of Northeastern Region. It was page 103. By this letter, my lord, it was intimated to the Planning and Development Department to furnish, and paragraph 2, it was mentioned to furnish the firm date of completion of the project and also to
Page
103, my lord.
So 2008.
Yeah, my lord.
Complex at Ikru.
In this paragraph 2,
Related to temporary or letter dated terms of forwarding Yes.
now after this, my lord, what happened? In spite of this letter and subsequent communication, my lord, the district sports officer and the principal secretary of Karbi Anglong Autonomous have not completed the, my lord, sports complex.
Till date.
Till date, my lord. After this, what happened, my lord? Page 105, your lordship will find, it starts from page 105 is the utilization certificate, which they said to be have utilized the money of first installment and second installment. But that was also, my lord, it is indicated in a remark they have given in the middle that utilization itself is cancelled by them. Meaning thereby, my lord, the project remain without completion, my lord. But now, if your lordship, what happened, my lord, when I came in PIL, my lord, page 111, without completing the page 111, annexure 16, without completing the diffuse sports complex, which was under the central fund of donor, my lord, they, my lord, the Karbi Anglong Autonomous Council, my lord, they adhered to build a auditorium, my lord, hall in the present location and site. That is a notified area for diffuse sports complex. Now they want to, my lord, build a indoor auditorium, indoor stadium. Auditorium is different, my lord, from the features of this diffuse sports complex.
Now, after this, my lord, what happened, my lord? I'm coming in a nutshell, my lord. On 11/4/23 date, my lord, there is an order of this court on 11/4/23. When I press for some protection to protect the nature and character of the land, since it's a notified for diffuse force complex. One undertaking was given on behalf of Caribbean Anglong Autonomous Council that there is no proposal for the present to construct an auditorium hall and over the same site, my lord. That is the located site is the same notified area for the diffuse force complex. One undertaking was given.
Yeah.
After that, what happened, my lord? Subsequently, the respondent 7, my lord, that is diffuse force officer, has filed one affidavit, my lord. In their affidavit at page 136. For a moment, if your lordship see page 136 of respondent 7 affidavit, they now say, my lord, that the play field is ready, is used for various sports related purposes. In this regard, I would like to request you to foreclose the said scheme. Now, all of a sudden, my lord, a contradictory stand has been taken by diffuse force officer who wants to foreclose the project without submitting any utilization, without completing the project, my lord. They want to foreclose the said scheme. And interestingly, my lord, this foreclosure and justification, whatever shown, is not communicated or to the Ministry of Donor, my lord, who is providing the fund. So secondly, my lord, after this, page 130, if you also will see, a statement has been made by in the affidavit, page 130. It starts in paragraph 16.
In the year 2019, they have said they already completed the project.
No.
136
Page 136.
or 140, whatever the page. Annexure 3.
They have not completed a project. That is the contractor stand there every time they are checking. Your lordship will kindly see, they are saying, my lord, they are building an indoor stadium. Now, my lord, from their photographs, they build a auditorium hall, my lord, instead of closing.
Where is that auditorium?
Auditorium hall, lordship will see the photographs, page 146 in the affidavit. They have built some auditorium hall.
Auditorium hall is apart from the whatever the stadium.
They have stated, my lord, paragraph 16, page 130. Their stand is that they have admitted that, my lord. Page 129, may I read it, my lord, for the moment?
Yes.
Page 129, paragraph 16. That a special grant of rupees 260 crore was granted by Gokta Assam to Caribbean Anglong Autonomous Council for construction of auditorium indoor stadium with gallery and open space during the financial year 2018-19 for 26 MSC constituency. One in each MSC constituency. Accordingly, out of the fund meant for the stadium in Lambajam MSC constituency, the works which could not be completed, this is my line, of diffuse sports complex project due to non-release of fund of NLCPR project. This is also not correct, my lord. The spectator gallery and pavilion and two-story pavilion with rooms for players are constructed by the PWD from the special package granted by the state of Assam for construction of stadium for the Lambajong MSC constituency. And thereby, my lord, they have admitted one that when they have given an undertaking on the court, that they are not going to alter or change the, my lord, this notified
This
area.
auditorium is constructed recently or it was constructed earlier?
Recently, my lord, in 2021, when I came, my lord, in 22, my lord.
So it was already constructed when they.
Halfly constructed, my lord, without utilizing without completing the diffuse sports complex.
But it was constructed when?
In 2022, my lord.
And you approached this court in the year?
2000, not 22, I'm sorry, my lord. When I came to a court, they have not built a auditorium hall.
It is recently built up.
Yes, yes.
Yes.
Lordship, and look into my lord, paragraph 6 of page 124 of affidavit, Karbi Anglong Autonomous Council,
Paragraph 6.
paragraph 6. The whatever the fund, my lord, that out of the fund release amounting to rupees so and so, the following works were executed. Last line, my lord, but due to non-release of the remaining fund of rupees so and so, the whole project could not be completed. And it was a project of 2004 and 5, my lord. Subsequently, my lord, Assam government allotted 10 crores rupees for 26 MSC constituency. And accordingly, my lord, the works which were executed out of that fund, my lord, that does not include the auditorium, my lord. That we have already stated. The other works which could not be completed in 2004 and 5, certain works were completed. So, lordship, we wrote to the ACD department about my lord NLCPR project, which is at Annexer 5, page 140. And by the last order, ACD department was directed to file the affidavit. Annexer 5, page 140. To the secretary, my lord.
My lord, here if
With
I.
references, I am forwarding here the justification report for foreclosing of the NLCPR project diffuse sports complex to Tianla as received from the district sports officer Rifu Karbi Anglong. So we send a proposal for foreclosure of the NLCPR project as it was a project of 2004 and 5. We have not received the fund from the central government. So the fund received from the state government as a special grant for construction of the stadium in 26 MSC constituency, the fund which were allotted by the government of Assam, the spectator gallery which could not be completed by the earlier central government fund, that was my lord work done, and we have submitted the affidavit and the photograph also. Regarding the auditorium, my lord, if the petitioner file an additional affidavit that we have constructed the auditorium with the photograph, my lord, then we can revert it. He may file it affidavit, not by verbal submission, that we have constructed the auditorium in that particular sports complex. And the AC department
Yes, that you have not constructed any.
auditorium, my lord. My lord, we have only the project which could not be completed, that has already been constructed.
No, they have not filed this affidavit. Wherefrom they are saying is that this is a district
They are
sports
telling
office.
you file an affidavit that
Well,
they have constructed a auditorium in the playground.
Yes.
Well, our stand is
Or
that,
in
my
that
lord,
complex.
our stand is that they should complete the diffuse sports complex.
They have
which-
already completed and the scheme was closed in the year 2019 itself.
Not close, my lord. They are seeking to foreclose it, my lord. That is,
140, sir, page number annexure 3.
this is the affidavit of respondent, my lord, 7, my lord.
The
District
play
sports
field is
officer.
usually various sports. In this regard, I would like to request you to foreclose the said scheme under CPR. This is what they are seeking.
My lord, your lordship will kindly see the copy to the, they have not intimated the copy to the Ministry of Donor. That is the thing. Without taking any, my lord, permission and without informing them, they are the authority.
Once the sport complex is already constructed, it is used by the people.
My lord, your lordship kindly consider one thing, let them file their affidavit. They have not
What
filed.
affidavit?
They have not filed their affidavit. Respondent 6, my lord.
What
Principal
affidavit?
Secretary,
What affidavit you want?
to place on record the, my lord, the correct facts, my lord.
There are so many facts on the
Your
record.
lordship will kindly see the photographs. The photographs they are annexed
Yes,
in the respondent 7.
yes.
They say that they have constructed one stadium in paragraph 16. I mean, my lord, they have constructed, construction of stadium is going on.
Where is that, sir?
Paragraph 16, my lord.
It is already completed.
Not completed, my lord. I have also annexed some photograph,
It
my
is
lord.
for 20, that is the general statement in respect of 26 MSC constituency and my lord, and sanction of the project by the state government. Regarding that particular project, my lord, Lambajang Stadium, my lord, that we have utilized the amount for the works which could not be
This
completed.
affidavit is filed by whom?
District Sports Officer, my lord.
Not by the principal secretary, my lord.
Principal secretary.
Karbi Anglong Autonomous Council, my
My
lord.
lord,
They are autonomous body, my lord.
that it is a NLCPR project. The fund is released by the ACD department. So we have to require to write to the ACD department. So the last order, ACD department was asked to file the affidavit.
They have filed.
They have not yet filed that, my lord.
last order.
Lordship, SED department is newly implemented, Lordship. We
Newly
need
implemented.
some more time to file affidavit, Lordship. Newly implemented.
You see that also on screenshot, it could be.
Documents are being commenced, you state in the initial stage, you should
Nine.
say, I have-
Only implemented on
September 2020.
September 22, Lordship. Newly implemented respondent.
23.
September 22.
Three.
Three.
September 23.
Even though, madam, the 6 months, almost 6 months.
Lordship, I shall take instruction.
They submit the utilized report, man. They are the authority who submits utilization certificate.
22 work on it.
You have what respondent numbers?
Respondent number?
You may also give your reply in the meantime. Mr. Gonsalves, when we are granting time to her, you may also file your.
My lord, that whether we have constructed the auditorium, they are not, my lord.
Take for and granted time to file their counsel to. This one so and so. Yes.
They should provide the appropriate information regarding the present status of the land.
We have granted them time.
Yes.
Let them file their response. Then we'll see.
53 call, sir. 53.
53 call.
Item 53.
Obliged.
Yeah, Mr. Lord. Petition is filed against the my lord impugned judgment passed by the Land and Central District Tribunal.
Readings are complete. Readings are complete. Okay. At 2.
Yeah, Mr. Lordship will find impugned order, my lord, of tribunal at page 34. By which the prayer of gratuity and regular pension has been, my lord, rejected. The petitioner has retired for service, my lord, on subordination, my lord, without any DP and without any complaint from the department, my lord, only on the ground that there was a private criminal case was pending.
Private?
Criminal case was pending against the petitioner.
Case is pending against.
Pending is the petitioner. And on that case, petitioner was convicted. And that is under appeal before this Honorable High Court. And stay has been granted, madam.
Stay.
Stay has been granted, sentence has been suspended.
Sentence has been suspended.
Suspended.
The conviction has not been stayed.
Stayed, madam.
Conviction also is stayed.
Also stayed, my lord.
Where is that order?
Order is not with me, my lord, but it is recorded, my lord, on by this court's order dated 15/11 while issuing the notice.
In case number 14, CBI convicted the petitioner on the prevention. Superintendent reports on some. Show us, where is the order of conviction of that stay of conviction?
Lordship,
There
then,
is
my
a
lord.
difference between suspension of sentence and suspension of conviction, sir. Suspension of sentence is somewhat different. Only the sentence is suspended. Whether the conviction is suspended or not.
She's on bail, my lord.
Maybe he's on bail on account of suspension of sentence.
Yes, my lord.
Not on account of this suspension of conviction. Finding is recorded and you have been convicted. That finding is still there. But the tribunal has held.
Tribunal has said only that my lord, lordship will find page, finding a lordship will find, page 45.
45.
Last para 5, my lord. Sorry, my lord, that is the finding of the, my lord, department. Your lordship will find, the finding is your lordship will find at last page 42, para 9.
42 of what?
42 of my petition, my lord. Well, but the extent rule, my lord, only 10% of gratuity can be upheld under the rule 10(1), my lord, and also the office memorandum, because, my lord, if there is any recovery and if there is any damages of the department, my lord, and in case of any DP and departmental proceeding is pending, my lord. So this is the totally, my lord, error committed by the tribunal, my lord. Only on the ground of conviction under section 7 of PC Act, my lord, and under 420.
The impugned order is this.
Is passed by the member only, my lord, not judicial member, administrative member. On this point also, my lord, this is not.
Carries the same way. Even though if the order is passed by the judicial member or the administrator, it carries the same weight.
Same weight, no, my lord. But, my lord, nothing has been discussed regarding, my lord, my gratuity and pension is a property, my lord. Only under the rule and gratuity act also section 4, only 10% can be upheld, my lord, from the gratuity.
For what reason?
Reason is that, my lord, only in case of,
what eventualities?
only in case of ongoing disciplinary proceeding and also departmental mismanagement and also departmental, my lord, if there is any financial embezzlement and recovery.
There is no provision for that. If a person is convicted, then what is the provision? If a person is convicted for an criminal offense.
My lord, that is extra departmental, my lord, complaint. No departmental complaint, nothing, no FIR by the department.
So which order of the, or which order of the, this, or which provision of the law of the gratuity and pension you are relying on?
Lordship will find the official OM page 116, my lord.
116.
116. This is the memorandum, my lord, where it is mentioned that only office memorandum, only 10% of gratuity may be withheld pending receipt of further information. Amount gratuity is to government servant immediately or production of demand certificate by state officers. And also thereafter, my lord, next 117, there is also office memorandum is also there. And as per that memorandum also, my lord, only in 3 count, para 4, page 117. Only in case of my ongoing disciplinary proceedings and outstanding license fee, and if any recovery is there, my lord. So totally, my lord, non-consideration of this OM and also the rules, my lord.
What is your response then?
Lordship, railway authorities that followed the rule 10(1)(a) and 10(1)(c) of Railway Services Pension Rules, Lordship, page 128.
128.
The extract of the rules, Lordship. And also Master Circular.
Yes.
Page 128, Rule 10(1)(a) and 10(1)(c).
Yes. Read.
Provisional pension where departmental or judicial proceeding may be pending. In respect of a railway servant referred to in sub-rule 3 of Rule 9, the account officer shall authorize the provisional pension not exceeding the maximum pension which would have been admissible on the basis of qualifying service up to the date of retirement of the railway servant, or if he was under suspension on the date of retirement, up to the date immediately preceding the date on which he was placed under suspension. And C, Lordship, no gratuity shall be paid to the railway servant until the conclusion of the departmental or judicial proceeding and issue of final order thereon, provided that where departmental proceeding have been instituted under the provision of the Railway Servant Discipline and Appeal Rule 1968 for imposing any of the penalties specified in clauses 1, 2, 3A and 4 of Rule 6 of the said rule, the payment of the gratuity shall be authorized to be paid to the railway servant. And also the Master Circular number 60, Lordship.
Admit it and list it for final hearing.
Plus.
Any day. Okay. I think it's also non-concept of the party. We are of the view that the matter requires consideration, hence admit parties are represented. Therefore, no need to issue notice. List for hearing in the month of June 2024.
Obliged.
Supplementary list item 62.
Yeah, बेकार फोन कर रहा हूँ। निकाल
14(1) का प्रोविजन में बोला है। Mr. Goswami, when is your client due for retirement?
31st March.
Huh?
31st March.
Of this year?
Spirit of the order.
Yes, conditional. That's effective. It's transient.
Yes. Already earlier submissions.
Yes. I filed it.
Written submission there. Written submission. Yes.
I filed a written submission today.
Yes. Would you like to counter that or?
No, Lordship, from the record itself, I will, Lordship.
Okay. Anything else you want to add?
I've given everything. Only thing, if you're I can take your lordship through 14 and 16 once again, and that will be suffice. Because all the decisions which I have given, which are required on the for interpretation of this statute, including craze. And if your lordship say, I'll just say two lines, and then.
Yes.
My lord, let me be at ease first. I must tell my lord, even after putting in 48 years, I feel nervous before your lordship.
Why is it?
That's the majesty of the court.
No, not at all. Sir.
That's the majesty of the court. We at this side, we always think the process of thinking is on how do I convince the judge.
The process, not a process of thinking, it's a process of learning.
Then, my lord Justice, the previous Chief Justice, Justice Mehta, my lord, a very, very well read and very knowledgeable Chief Justice, we get very sure of them.
With him, my lord, I had the occasion to argue a big matter, a criminal appeal. And he used to say, my lord, that learning never ends. And I also feel the day I feel that I know everything, that will be perhaps my end.
That's right.
Therefore, we learn from each other, in fact, decide more. And when my lord, there is a conversation between the bar and the bench, the bar gets enriched.
Even the bench is also at the count of that.
Now, my lord, it is not in dispute. 3 dates are not in dispute. Number one, that Dr. Sasi Bhushan, Institute of Teacher Education, came into being after the appointed date. That is 1/7/1995. The recognition was granted to this institution by the Assam University Silchar on 5/7/1996 in gross violation of section 16 of the Act. Gross violation. I will just show, will take your lordships through the, Lord, I have compiled everything, the judgment that I will cite, and also NCTE Act. I've come. My lord, may I, my lord, take your lordships through one definition, definition of examining body, because this is an expression which has been used under section 16 of the Act. Your lordship may turn to page 3 of this is National Council for Teacher Education Act 19. Well, 2D, your lordship. Examining body means a university, agency, or authority to which an institution is affiliated for conducting examination in teachers' education. So it will be a university. Now, my lord will kindly come to the next I. I is recognized institution, means an institution recognized by the council under section 4.
I.
2I, my lord.
2I.
At page 4.
A school established, owned and controlled by the central government.
No, my lord. It's just below H, my lord, at page 4. F, G, H, then I.
Yes.
Recognized institution means an institution recognized by the council under section 14. Now, first I'll take your lordships to the bar under section 16, and then I'll come to 14. 16, my lords will get at page 10. At page 10. Affiliating body to grant affiliation after recognition or permission by the council. Notwithstanding anything contained in any other law for the time being in force, no examining body shall, on or after the appointed date, grant affiliation, whether provisional or otherwise, to any institution. Second one is even more stringent, my lord, more severe bar. No examining body shall, on or after the appointed date, hold examination, whether provisional or otherwise, for a course or training conducted by recognized institution, unless institution concerned has obtained recognition from regional committee under section 14 or permission for the course under section 15. There is a clear bar that any institution even recognized institution, my lord, if it is on or after the appointed date, unless it is affiliated, it can't even hold examination. There is a mandate of law, and my lord, your lordship knows very well these are, my lord, regular thing, but there is a, my lord, decision of 2004 which explains notwithstanding. That I will take your lordship. COVID. My lord, page 17, if my lord will kindly see, page 17. Page 17, my lord. In fact, this compilation I was given in the port only. My juniors were preparing, so there will be some. 17, my lord, your lordship will say, there's a division bench of the Supreme Court. Paragraph 11 would be relevant.
Paragraph
11 at page 18. No, page 18, my lord, of the compilation. It is this one, my lord, which I have given. I'll not take any other paper, my lord. This is from here. I will refer everything. The compilation.
Union of India versus GM College.
My lord.
GM Kokil.
Kokil. Union of India versus another's versus GM Kokil and others. The relevant paragraph is at 11. My lord. Third line from the top. It is well known that a non-obstante clause is a legislative device which is used, employed to give overriding effect to certain provisions over some contrary provision that may be found either in the same enactment or some other enactment, that is to say, to avoid the operation and effect of all contrary provisions. Now, therefore, section 16 begins with non-obstante clause, notwithstanding. And its mandate is that no examining body can grant affiliation or hold examination conducted by even recognized institutions unless that institution is affiliated under the Act. That's the mandate of the law. Now, my lord, I'll take your lordship back to 14. Same compilation, my lord. 14. My lord will get at 9, page 9.
Yes.
14, I'm reading. Every institution offering, these are the existing institutions, or intending to offer, this will be institutions which are not in existing, intending to offer a course of training in teacher education on or after the appointed date may, for grant of recognition under this Act, make an application to the regional committee concerned in such form or in such manner as may be determined by regulation. Your lordship will kindly mark the word regulation, because the regulation came on 26th, was published on my lord, on 24/2/1996. The regulation, this your lordship will find at 239 of the paper book.
24.
24/2/1996. 1996. This provides the form and the manner in which a recognition will be granted. The lordship can see there are forms. So now I'll place it again for your lordship's consideration. Every institution offering or intending to offer a course of training in teacher education on or after the appointed date may, for grant of recognition under this act, make an application to the regional committee concerned in such form and in such manner as may be determined by regulation. Single judge is talking about the rules. Rules doesn't come in. Regulation provides, and it has come. Of course, the time was little less because the first proviso which I will read, which is meant for the, my lord, existing institution, it says that they can continue to provide a course or a training in the teacher's education, provided they apply for recognition under this act within 6 months. But that 6 months, the regulation came 1 month maybe before the completion of 6 months. That is how the NCT extended it, my lord. The time it was extended. And the reason given is not that the rules have not come into force or the regulation is not come into force. The reason is that many of the institutions did not know about it. I can just take, my lord, through that. If your lordship will take the paper book appeal memo at page 73. Page 73.
Yes.
I am to draw your kind attention to the fact that according to the provisions contained under Section 14 of the NCTE Act 1993, every institution offering a course of training in teacher education before appointed date, that is 17 August, this is not correct, this is 1/7, I have placed the notification, has to apply for recognition to the concerned regional committee of NCTE within a period of 6 months from that date. The provision of the acts are applicable to all colleges and department education in all university offering B.Ed and the teacher education course. It is mandatory for all teachers training institutions to obtain recognition from NCTE. Then the reason comes for extension. Due to lack of information about the procedure, many colleges or department of education did not apply for recognition within a stipulated time. The procedure and norms standard for recognition have already been notified in Gazette of India. This I have taken your lordships. This is 24/2/1996 of India by Council in order to provide fresh opportunity to non-applying colleges and Department of Education. The last day for receipt of application by our 4 regional committees of the council has been extended up to 18th August 1997. So the reason is not that the regulation has not come into force. The reason is that it was late perhaps, and they did not know about it. There were no information, and that is how this has been extended. And this was under challenge, which has been relied by the learned single judge. This was challenged, and this is what, my lord, the judgment of the division bench at page 185, paragraph 5 refers the question. This is the question, whether they have power to extend. And your lordships held that yes, they have power.
Son,
That's not a.
If the regulations come into force in the year in 1996, but no procedure was there.
No, procedure is there. Procedure is there, form is there.
Procedure?
Yes.
That's
lordship-
why only due to lack of information
No,
about
no,
the
that-
procedures.
No, at that
Many of the
next
colleges
line,
did not apply recognition within stipulated
next line,
time.
in my lord, your lordship will see, the procedure and norms standard for the recognition have already been notified.
Which day?
That date I have seen, 239, your lordship will see. I have already shown your lordship. 239. $239.
29 December 1995.
This was published in the Gazette on 24/2/1996.
1996.
Yes.
So.
And your lordship, yes, my lord. And your lordship will see. I'm reading, my lord, Regulation 3A. Regulation 3A. At page 39, 239.
Yes.
Every institution offering a course or training in teacher education immediately before 17th August 1995 shall make an application for recognition under the Act to the Regional Committee in the form given under Appendix 1 to the schedule. And in any view of the matter, this applies only to the existing institutions which were in existence immediately before the appointed date. It will not apply to an institutions which came later on.
It was every institution.
Yes.
Intending to offer.
Yes,
Yes.
yes, my lord.
B.
There are two things. Intending to offer a course in training teachers shall make an application. They also, because 14.1 applies to both. An institution which is offering and institution which intends to offer. It applies to both, 14.1. But the proviso to 14.1 applies only to the existing institution. And there is no doubt about it, my lord. There cannot be two construction of this. There cannot be two interpretation. I'll place the proviso, my lord.
Yes.
I'll place the proviso now. 14. Proviso, first proviso to 14.1. Page 9, my lord, of this compilation. Provided that an institution, page 9, my lord,
Yes.
provided that an institution offering a course intending to offer is gone, or training in teacher education immediately before the appointed date. So it rules out any institution which came after the appointed date, shall be entitled to continue such course or training for a period of 6 months. If it has made an application for recognition within the said period until disposal of the application by the regional committee. Well, this proviso is meant for the purpose of continuity. Suppose an institution is offering a course or a training in teacher education before the appointed date. The students are already admitted. They are studying. And an NCT Act comes and says, from appointed date, you cannot, your even examination will not be held. So in order to provide continuity of what has already been happened, this proviso was given. This proviso has nothing to do with an institution which was not existing in existence before the appointed date. This is my submission. And my lord, your lordships are well aware. I'm just repeating it because there's nothing that your lordship do not know, but perhaps I can refresh your lordship's memory. My lord can have compilation this. And I'll take your lordships first, my lord, to a constitution bench decision, M.H. Qureshi versus State of Bihar. Page 20, my lord. Page 20.
20.
20, my lord. The AIR 1958 Supreme Court, page paragraph 15, and Manu SC 0027 of 1958.
Muhammad Hanif Qureshi.
My lord, Muhammad Hanif Qureshi and others versus State of Bihar. The relevant paragraph is 22, my lord.
22.
22.
Yes.
My lord, for my purpose, if your lordship can look into the lines, 3 lines, 10th line from the bottom. of paragraph 22. Just 3 lines
Yes.
about the legislature. The courts, it is accepted, must presume that the legislature understands and correctly appreciates the need of its own people, that its law are directed to problem made manifest by experience, and that its discriminations are based on adequate grounds. They are the best judge. Therefore, my humble submission would be that if something is not there in a statute, your lordship, with all respect, cannot read it unless your lordship is dealing with the constitutional validity of the act, in which case your lordship can read down. And my lord, recently I have come across a case where it's a case from Assam and 2 other cases, where my lord, section 10(1)(a) of the Unlawful Activity Prevention Act 1967 was under challenge. My lord, a division bench of 2 judges headed by Justice Markanday Kadju brought in the American doctrine to say that guilt by association is not permissible. And he says mere membership will not be an offense. And he happened to deal with 3 cases within the period of less than 3 months. Now, the government of India filed a review petition, which was recently taken in 2023 by a 3 judges bench headed by Justice Shah. I have an equivalent justice, that judgment says that there is no question of reading down any provision of the act unless the constitutional validity is challenged. I never come across such an emphatic decision, my lord, on the point. I have a next that. I will page 72. Page 72 of the same compilation. Arup Bhuiya versus State of Assam. My lord, Justice Suman Shah must have seen this judgment. '61, no? 70. I have annexed only relevant portion, my lord, at page 74. This is Arup Bhuiya versus State of Assam. Yeah. Paragraph 61, my lord, at page 74. Even otherwise, in absence of any challenge to the constitutional validity of section 10(a) Roman 1 of UAP Act, there was no question of reading down the provision by this act, this court. Therefore, in absence of any challenge to the constitutional validity of section 10(a) Roman 1 of, I don't like to call it UPA, so I say UAP Act 1967. There was no occasion for this court to read down the said provision. Now, in my humble submission, my lord, the first proviso to section 14 has to be read as it is without adding or subtracting any words. This is my submission, my lord, from this. My lord, for a moment, if I can take your lordships through praise on a statute law. Same page 91, page 50. The relevant will be 91. Yes, of that. Page, my lord, this is the first page we have put at page 50. Praise on a statute law. The next page, if my lord will kindly turn, we have only given the relevant one. The book is there. I can hand over.
Which one?
Praise. I have given the relevant one. I'll read the relevant one. Otherwise, I'm carrying the book. My lord, if your lordship,
Yes.
the lordship required. My lord, at page 51, 7, paragraph 7, limitation on judicial modification of language of an act. I'll read only 10 lines from the top. It is not, however, competent to a judge to modify the language of an act of parliament in order to bring it in accordance with its own view as to what is right or reasonable. So and so, no doubt, said Justice Willis, the general rule is that the language of an act is to be read according to its ordinary grammatical constructions, unless so reading it will entail some absurdity, repugnancy, or injustice. But I utterly repudiate the notion that it is competent to a judge to modify the language of an act in order to bring it in accordance with his view of what is right or reasonable. But I am submitting it because I would beseech your lordship to read first proviso of section 14(1) as it is. And if your lordship reads that way, the institutions which are not existing as on 1/7/1995 would not come at all, especially in view of section 16(2). Then my lord, there's so many decisions, but I'll read only one or two and I'll stop there. My lord, a constitution bench decision, another constitution bench decision in Union of India versus Hansoli Devi. This is, your lordship will get at page 59 of the compilation. Page 59. This is by constitution bench judgment. Paragraph 9. My lords will get at page 66, my lord. Nine.
Yes.
My lord, I'll tell you. Before we embark upon an inquiry so as to what would be the correct interpretation of section 28A, we think it appropriate to bear in mind certain basic principles of interpretation of a statute. The rule stated by Chief Justice Tindall in Sussex Peerage case still holds the field. The aforesaid rule is to the effect: if the words of the statute are in themselves precise and unambiguous, then no more can be necessary than to expound those words in their natural and ordinary sense. The words themselves alone do, in such a case, best declare intention of the lawgiver. It is cardinal principle of construction of a statute that when the language of a statute is plain and unambiguous, then the court must give effect to the words used in the statute, and it would not be open to the courts to adopt a hypothetical construction on the ground that such construction is more consistent with alleged object of the policy. In so-and-so, Lord Reed pointed out as to what is the meaning of ambiguous as held. The provision is not ambiguous merely because it contains a word which is different, which in different context is capable of different meaning. It would be hard to find anywhere in this sentence in any length which does not contain such word. The provision is, in my judgment, ambiguous only if it contains a word or phrase which in that particular context is capable of having more than one meaning. Then, my lord, if your lordship will come to Placitum D, just below that, Placitum D, just one line below Placitum D, in Quebec Railway Light, Heat and Power Company Limited versus Vandry, it had been observed that the legislature is deemed not to waste its word or say anything in vain, and construction which attributes redundancy to the legislature will not be accepted except for compelling reasons. Similarly, it is not permissible to add words to a statute which are not there unless a literal construction being given a part of a statute becomes meaningless. But before any word is before any words are read to repair an omission in the act, it should be possible to state with certainty that those words would have been inserted by draftsmen and approved by the legislature had their attention been drawn to the omission before the bill had passed into law. At times, the intention of the legislature is found to be clear, but the unskillful fullness of draftsman in introducing certain words in the statute result in apparent ineffectiveness of the language. And in such a situation, it may be permissible for the court to reject these surplus words so as to make the statute effective. This is what it is. Then, my lord. Then, my lord, I'll just place the last decision.
1 minute.
Equity.
Yes.
The last decision, my lord, is your lordship's where sometimes I feel that I'm wasting time on the court because your lordship knows. My lord, your lordship knows no equity against law. That's not something. Anyway, I have an this, so your lordship made page 75.
Go through all.
My lord, please. Now, this is, my lord, a case which was giving both a roller coaster ride. This is the case. Because during the pendency of the selection only, I challenged his degree. And I made a representation on 2019 that his degree is valid. But result was out, he was above me.
How many persons participated in that?
My lord, that fact is not there, but it appears that there were 3 persons. 3 persons. He was first, and second was me and the other person.
Either of them?
No, it's a joint declaration.
Joint.
My lord, and I have no hesitation to add that drafting is not up to mark. The drafting.
P-days?
Drafting, I'm saying, drafting of proceedings. I'm saying that I have myself seen it. But yes, something can be made out from there. Now, then, my lord, the appellant came up before your lordship in a single bench. Then, as per pleading, he was assured by the government or the officers that you withdraw your writ petition, we'll address your problem. So he accordingly withdrew. This is, of course, pleaded. After that, his degree was held to be invalid. My lord, kindly come to 80. And the same authority later on, in the second round, holds his degree as valid. Your lordship will kindly come to page 80 of the paper book writ petition.
That decision of the authority of invalidating his degree was challenged before this court?
Was challenged and the matter was remanded.
Remanded.
Yes.
In remand, the
Same authority said, so first, when I went to court, he said, it will be done. He gave order in my favor. He went, matter was remanded, and he gave order in his favor. That is how I have challenged in the present writ petition.
Mr. Consul, suppose we are not, this is not even a prima facie opinion. Suppose you succeed in this
Yes,
matter.
yes.
What is the guarantee that you will get the appointment?
No, I've already been appointed. It is on record. I'm already and I'm continuing. I was appointed.
Last.
I was appointed. Appointment depot course. Yeah, he's continuing.
Please continue.
I was appointed, your lordship will see at page 81. I was appointed and I'm continuing.
After cancellation of his appointment, you were appointed.
Yes. Yes. That's why I said, my lord, we had a roller coaster ride. Now, my lord, but coming, my lord, back to the question of laws which are involved here. My submission is that they cannot, by no stretch of reasoning, they can say that the degree was valid. For the simple reason that recognition is on 5/7/1996, whereas the Act came into force on 1/7/1995 in view of Section 16. This is my submission. I'm all done.
I'm on the facts in the same logic. Kindly see letter page 73.
Page
73.
73, yeah.
Logic. This is a letter to the Registrar of Assam University.
I've already paid.
73 is the letter by National Council for Teacher Education.
To the Registrar of Assam University.
Dr. Sunil B. Mohanty, Deputy Secretary to Registrar. Okay, fine.
Assam University.
Yes.
Lordship, this letter has been informed to the Registrar of Assam University, informing that the procedure, Lordship already read, procedural norms and standard of recognition has already been notified in the Gazette of India by the Council in order to provide fresh opportunity for non-applying colleges, not existing colleges. For non-applying colleges and Department of Education, the last date of receive application for Regional Committee of the Council has been extended up to 18 August 1997. That is first. Second, Lordship will find, para 5, page 74. They were that there are 4 recognized colleges under the Assam University. In view of the position explained above, there is an urgent necessity for all colleges and university department education offered B.Ed course of teachers training course to apply to the concerned regional committee of the NCT for recognition. It is requested that you may please seek necessary instruction to all colleges affiliated to your university and offering teachers training course as well as to Department of Education to immediately apply for recognition well before 18 August 1997. They were aware that there are affiliated colleges and institutions under the Assam University. They have not deferred that you should not continue the affiliation and you should not hold the examination. After the lordship, the petitioner has applied for the recognition. This letter has been given. Immediately, petitioner, institution, and all other institutions under the Assam University, that is a central university, applied for recognition. There is no bar for that you should not existing, not existing, nothing. And they have not barred the existing institution or non-existing new institution. There is no bar. Secondly, Lordship will find what had been placed my senior. Lordship will kindly see the notification. Page 238.
39.
238 is initial. Page 238 is the notification regarding regulation note, what they have stated.
Procedure, that is
procedure. Lordship will kindly see page 238.
Yes. The
Lordship
Gazette
will
of India, February 24, 1996.
Yes, Lordship. Now, Lordship will take to the last New Delhi, 10 January 1996. Then, short title and commencement. This regulation will be called National Council for Teachers Education Procedure relating to meeting of the council and quorum for such meeting and regulation 1995. DSL came into force on the date of publication of the official gazette.
You're reading from 238.
Page 238.
Right. Short title and these regulations may be called National Education Application for Recognition and Manner for Submission, Determination of Conditions of Recognition of the Institution, Permission, Start a New Course of Training, Regulation 1995.
Lordship is right. Next second column, Lordship will find. Second column, last portion.
Column.
10 January 1996.
This came into force on the last date of publication of the official gazette. Lordship,
Referring to page 239. That means
In
you are
the
referring.
initial also, last date of, in the first column also, this cell came into force on the last date of publication of the official gazette. Lordship got it. In the initial first paragraph also, this cell came into force. In the first paragraph below, Lordship, before 2, rule 2.
Mr. Goswami, you are reading from page 239.
238.
238
is
238.
this typed copy,
The typed
relevant
copy.
portion, annexure G.
238. Down below or in the initial
On the right side.
right side.
Right.
This is 239.
No, there is a pagination problem.
238 on the right side.
Here it is 239.
Oh, maybe.
Yes, then 238.
239.
Also referring to 230.
It is silent, Harry. Tell them to check it, if the pagination is okay or not.
Good night. 238 to the 238 to the
No, 238 is different here.
238 objection or correction point say only one day.
Your lordship is right. It's not that.
First of all, you correct your pagination. I think so. The document which you are referring to is not on the record.
Lordship. So though it is Lordship not on record, they have wrongly annexed the documents, but date of publication in the official gazette implies as per rule. In the second page also 238, Lordship has 239, Lordship has seen 239. Lordship has said page 239 is there, Lordship. 239 also Lordship is in Gazette of India, 24th February 1996. Lordship got it.
You based on record the correct copy. Thursday will continue. On Thursday we'll continue.
Yes, Thursday 15. Meanwhile, we will replace it. We'll correct the records.
With the correct one.
I'll correct.
On Thursday.
My lord.
We'll complete on Thursday. So far as regarding your arguments that are over.
He has completed, Lordship. I will give a reply.
Okay, 5-10 minutes we will complete.
You counter, then I will give a reply.
Somehow they want to make the delay, Lordship. I retired.
I have completed. He says I want to.
It seems you both have decided to grill us. That's okay. Now on a lighter note.
Lordship. I understand.
Thursday.
Okay.
Thursday.
Daily list for final disposal, item 54 to 57.
Yes.
I have received a communication a while ago, Your Lordship. Lordship, in this matter, wide order dated 24th of August 2023. Census report was directed to be filed regarding the tribal belt and blocks of the entire state of Assam. Regarding that census report, Your Lordship, the department required some more time, Your Lordship, because the reports are half collected and a few more districts are yet to.
Item number 54.
54 to
57.
57. Yes.
54 to 57.
The order was passed in the PIL 78, 2020.
They need some more time.
Only thing is, my lord, our interim order will have to be extended. I have a submission, ma'am.
Item number 56, my lord. I filed an application for vacating the interim order, my lord. Basic, yes, my lord. And there is an order from this honorable court, my lord. Order to vacate. 20, yeah, my lord. 28, 6, 2023, my lord. 27, 6, 2023. That this matter require prolonged hearing, pleading on behalf of some party are still awaited, may be fixed next week. We make it clear, no further time shall be granted for filing pleading in this case.
So without there being a report from the government, shall we proceed?
Yes, my lord, because my humble submission before your lordship is there. My stay vacating application has been pending by long back. And in that case, affidavit has been filed by the government in my cases. So, my lord, my humble submission that in the stay vacating application may be heard, my lord. It was filed on 2021, my lord. In item number 56, I filed this.
Without this.
Because it was tagged with the PI, my lord, that is it is come to the division rank. And this interim order is contrary to the order passed by the single bench.
Without there being any report from the government.
Yes,
then we can hear it.
Report has subsequently come in PI, my lord. My case is something different, my lord. As per chapter 10 of Assam Land and Revenue Regulation, my lord, in tribal belt and block, my lord, non-tribal people cannot transfer uses possession of the land. And that is 162 to CRPC. There's many judgment, my lord, of our High Court also, my lord. Now what happened, my lord, in this case, Revenue Board has passed an order, my lord. Circle officer said that the petitioner did not produce single document before the circle officer. And circle officer has passed an order. Thereafter, they come before the deputy commissioner, my lord. Deputy commissioner said that they are, my lord, in tribal belt and block, my lord. Document was not produced admittedly in tribal belt, so they may be evicted. Against that order, they are going to be Board of Revenue, my lord. Board of Revenue pass an order in my favor, my lord, stating that cannot transfer users possession in tribal belt and block. That order was not challenged, my lord. And my lord, there is an interim order has been passed, my lord, that he shall not be evicted from the place of rent. And my lord, thereafter, this case was found in the single bench. Subsequently, it was listed along with the division bench case, my lord. I filed an application for vacating the interim order. Under 226(3), my lord, it should be disposed of within 14 days, but it is 2 years, my lord.
Please.
Yes, yes, sir.
There should be disposed of in 14 days when you are appealing from this side.
Yes, sir.
Otherwise, if you are appealing
Yes.
from that side, it
Yes,
can
sir.
be
Yes,
decided
sir.
at any point of time.
Yes, sir. Your lordship is absolutely correct, my lord.
That
But 2 years, my lord.
Yes, sir.
Yes, sir.
2
Last-
years and wait for 2 months only.
Yes, sir.
Then file the report
What-
and then we'll consider.
My humble service is something different, my lord. That subsequently they have said they will make censures in the tribal belt and block land. And this land belongs to the tribal belt. They have already admitted in the writ petition also, paragraph 2. And my lord, the person concerned who said tribal, his tribal license.
Mr. Counsel, the only concern is that once the matter is connected, then we can't hear it in isolation.
And another case is that, my lord, there is an order passed by this division bench, my lord, honorable division bench, that you evict all the tribal belt and block people from the tribal belt, my lord. Considering this land also within the domain of, my lord, order passed by this honorable court, my lord. And single bench is contrary to the order passed by the division bench.
That we will examine, sir. That we will examine.
So, my lord, your lordship may sort that, my lord. I am waiting for 2-3 years.
Once if they are seeking time, why you are
Earlier, my lord,
2
several
months time for that report?
6 months, my lord.
Yes.
Several districts in the state of Assam.
Yes.
Yes, sir.
Yes, sir.
Several districts in the state of Assam. Regarding a few districts, the report are yet to be collected. That's why lordship and census report requires a lot of exercise, your lordship.
Then you file the report at the earliest, not 2 months. 4-5 weeks we can grant you the time.
I have been communicating with the department of the leads.
Convey them. The court is asking for this, that you should file the report not beyond 5 weeks. Convey them. Expedite the procedure, whatever you want.
6 weeks.
What is it? Okay, 6 weeks. By that time you will file?
They have assured that.
You are assured that. Okay, okay.
And one thing is that, my lord, in division bench, PIL has categorically stated, if you are not evicted non-tribal people from the tribal belt and block, from your salary should be cut off. There's an order. Thereafter they have come that census should be done, everything should be done, my lord.
Some procedure has to be followed.
This is the constitutional mandate, my lord.
Against the division bench order, an SLP was preferred. In SLP, certain direction has been issued. Perhaps my learned friend is not aware of.
Let them
That
produce.
order has been diluted.
Let us, it was not produced before the court, my lord.
Anybody wants, anybody wants to address the court? Okay, so and so for the state has submitted that that she has been instructed to seek 2 months time for for submission of the report along with the necessary documents. Stop. Having considered the fact that much time was already granted to the respondents to furnish the report, we deem it appropriate to grant last opportunity of 6 weeks to the respondent state to furnish the desired report. That's all. 6 weeks के बाद की date देने पड़ेगी.
Also, can we fix a date, file? Kindly give a date.
Yes, we're fixing a date after 6
After
weeks.
6.
Interim order, if I need to continue till next date.
Deep notes.
For hearing, item 52, 58.
Yes.
I prefer this appeal, your lordship, because the judgment of the honorable single judge, by which my late petition was dismissed, your lordship.
Who is for the other side? You are for the other side.
I prefer the department.
Okay.
You have the records?
Printout copies are here, scanned printout copies I have.
Last department will further time to produce the relevant record. So why you have not produced the record?
Scan copies they have sent me.
Whatever the report you may furnish it.
Original second get. Scan the scan copies are here.
And record, we will consider that also, but produce it on record.
I'll file an affidavit then,
File an
let
affidavit.
it be on Friday. I'll file it tomorrow.
Once the court order is there to produce the record, then produce in proper manner.
I'll bring it on record.
Just after a week.
Item 59.
Item 59, I appear for the appellants. Today morning, my lord, the respondents have brought to my notice that there was an affidavit filed in a connected matter which may have some relevance to this case, my lord. So I'll bring that affidavit on record. They have supplied me a copy. I'll bring that on record. It will help on the decision. My pleasure. There's an interim order, my lord, that continues. There was an interim
Is
order.
there any interim order?
My lord, yes, our posts.
Interim order, if I need to continue till next stage.
I'm obliged.
Item 61.
Sorry, man. May it please your lordship. Well, since this wheat appeal involves a public road and it was of 2024, that's why it was fixed for hearing because public interest is involved. This road has not been constructed due to this litigation in the High Court for the last 6 months, madam. And it involves the jurisdiction of, it has challenged the tender jurisdiction as well as the observation of the tender evaluation committee. Well, what has happened in this case, my lord? The read petitioner, who is the private respondent here, 1 and 2, he participated in a tender process of PWD roads for 4 works. And out of that, my lord, he filed 4 read petitions. In the other 3 read petitions, he knows that he will not technically qualified. So he did not press for any interim order in those read petitions. And those read petitions are still pending. So far this read petition is concerned, he knows that he will be technically, his bid may be qualified. That's why he has pressed for an interim order. Then this matter came up before the division bench earlier. Division bench of this honorable court granted the PWD authorities to examine all the matter afresh and taking into everything into consideration. The grievance of the respondent number 1 and 2 before the learned single judge was that the observation in regard to suppression of material facts cannot be sustained because as per the tender documents and the tender format, he has to disclose all his pending works. So far this tender process is concerned, my lord, he has said that the director, Matlebuddin Ahmed, and the Purbanchal Biltech are 2 individual identity. And that's why unlike in the other department of PWD, like the National Highways and all, where he has disclosed his other pending works, since there was no such observation from PWD roads, that's why he did not disclose the pending works. We brought to the notice of the learned single judge not only the 3 works, pending work which he has not disclosed in the prescribed format of the tender document, but he has also not disclosed another work which was awarded in favor of Purbanchal Tech Company Limited. So, and we had also brought to the notice of this learned single judge that so far Purbanchal is concerned, there also the private respondent, Matlebuddin Ahmed, holds
work is going on.
No, work is now has made the subject of the outcome of this writ appeal, and they had obtained a stay order. The writ petitioner obtained a stay order. The division bench had made it clear that any escalation and all during that pendency will be.
No, but the work in question shall be subject to the outcome of the writ appeal.
Now, this is the observation, last observation it was given in this case. So it was now work has not stayed, and we had made them. That's why it has been posted for.
Why it has not been started then?
There's no work. No, my lord, because it has made the subject of the result of the request, probably that's why they have not been.
There is no blanket stay.
No. It was made the subject of the result of the writ appeal because I was the successful bidder in the tender process, and initially that 6 months has gone. And probably, my lord, what has happened, why this delay has caused, my lord. I have come across a judgment of the Honorable Supreme Court in similar facts and circumstances. Your Lordship must be probably aware that that is NG Projects Limited. My lord, I have an extra.
Yes.
NG Projects Limited, my lord.
Says.
My lord, because to avoid this type of delays in tender process, my lord, the Honorable Supreme Court had directed that normally, my lord, the High Courts or the Honorable Chief Justice to entrust this petition to a division bench of the High Court, which should avoid at least hearing by one of the forums. That I think is not no notification to this effect. So far, our High Court is concerned till date, my lord.
Ultimately, now it's division.
Yes, that's why I have brought it to the notice of the Honorable Court. That's why that 6 month delay is concerned. But it's a very small issue. The PWD authorities have a prescribed format, and they have not followed that prescribed format, and there is suppression of material fact, which there is a categorical finding by the PWD authorities. So far, the private respondent number 1 and 2 is concerned. Now, your Lordship will find so far this
the whole controversy that he has not disclosed the
pending
works.
Yes.
And his case is that there is no such column or no such information which is required to be filled in by the.
No, his interpretation is that the 3 works which he have not disclosed is in the respect of the individual Matlebuddin, who is also the director of Purbanchal. So these 3 works were not disclosed to calculate the bid value. So far, other work is concerned, that is the name of the company that has also been not been disclosed. But the learned single judge has observed that this was disclosed. There was nothing in the material to show that this was disclosed. The 4th work.
He may not be available. No. Are you available on Thursday?
Only tomorrow I'm not available. I'm available on Thursday.
We'll go through the case.
Yes.
Because,
My learned friend was indicating about public interest. My lordship will find, once lordship goes to the facts of the case, public interest will be better served if my client is given the work. Because my rate is less.
No,
Rate is much less. And my lord, my technical bid was rejected on a ground.
That is for the state.
Yes.
That is for the state to consider.
Yes.
Yes.
But in fact, Mr. Chaudhary,
Yes.
I'd like to hear you on the point.
Yes.
In the tender matters, the Honorable Supreme Court as well as many other high courts
My lord,
has a clear view that there
My
must be least interference.
no, my
in
lord,
these matters.
correct, my lord. Due
Until
deference,
unless there is
due,
some malafide.
yes, here is, I'll show my lord. My lord, it's a question of malice in fact. Sorry, malice in law. I'm not saying it's a case of malice in fact. It's a case of malice in law. Though the act may be bona fide, but inherently, my lord, there is something else. My lord will kindly see, even if we add those three works, my bid capacity never decreases. My lord, the bid capacity required for this particular work is 19 odd crore. I have got 56 crore. My lord, the single judge has dealt with that point.
You mean to say that even though if you have not disclosed.
Yes, it has not made any material difference. And on top of that, my lord, learned single judge has clearly indicated my rate is much lower than the rate offered by my learned friends.
That may be one of the consideration, but not the sole consideration.
Yes.
And your lordship is correct. My lord, when there is a malafide, extraneous consideration and arbitrariness. There is no pleading in the, I don't find a single sentence of where these words are uttered.
We'll go through the fact.
Yes.
My lord, Tata Cellular, end of the day, that's the Bible as far as these matters are concerned, where Article 14 violation can be, otherwise, my lord, it will be too much to leave everything to the hands of the executive, my lord. Article 14 violation has to be looked into. Yes, NJ Export, Supreme Court has said, and now, my lord, specific relief act has also been amended, where in infrastructure projects normally, but exception is there. There's nothing like an absolute proposition.
No, that's why no exception for this court is there.
Yes.
Despite that.
And lordship will take a call on Thursday.
On Thursday.
Yes, I'm obliged, man.
State, we are also preparing appeal. For the state, we are also preparing appeal against state.
You are preferring appeal?
Yes, we are in the process of today, we are.
Do it. At
it
your
come on
convenience.
Yes, I'll make.
Thursday it will come.
I'll make a prayer for it.
Okay.
Do it at your convenience or make your submission in this appeal. We'll consider it. We can't wait for your